Hey guys, good afternoon. I'm so excited you guys are here to watch this with me today. We're going to get right into it. Let's do 1.25. We're going to skip some recesses, make sure we're spending our time efficiently. And we're going to get into it. I hear we're talking about some Bruton stuff and Gotti statements, and it's going to be a good time. So here we go.
They'll announce the time to orient, but this is now Detective Dennis's voice, who's mentioned Mr. Stillwell swung first outside a club Crucial. That's the fight that you've been hearing about on the
Hold on, did the Law and Crime feed have two different feeds today? Because this only says that it's been going on for like an hour. So let me make sure I'm not skipping some stuff. Let's go to Law and Crime. Law and Crime. That doesn't look like it's been a long enough stream. They started at 12:30, right? All right, no, only one day. So wow, they haven't been going that long, have they? All right, they started right in the middle. I'm not crazy. So did Law and Crime miss something? Should we try? Let's try Infamous Sylvia. Well, give me 1 second. We'll start from the beginning. So let's do this. So why did Law and Crime start late? That's weird.
All right, I'm going to take a second and get everything logged on and signed in.
This should be better.
Anybody have any preferences to, oops, the sound just went out. And now it's back, but yep, just went out again. Yeah, I'm not even going to say cautiously optimistic that it was actually fixed.
Oh, so they were
And now we
late
know
starting
that it
today
was not, in fact, fixed.
because of the camera?
All
What
right,
is going
anybody have
on?
anything they need to report? Any developments?
Judge, we're still working with Ms. DeWilliams and Ms. Abbasi. We're still looking at the, I'm sorry. We're still working with Ms. DeWilliams and Ms. Abbasi. So we're still working with Ms. DeWilliams and Ms. Abbasi on the Rodelius Ryan exhibit. So we're working on those.
Okay.
We won't. We'd rather continue working on those than even attempt to start addressing that part
Okay.
today.
That's fine.
Yes, Your Honor, we're going to wait to file our motion in limine because we are working with the state, and we want to make sure we're not wasting the court's time.
Okay, I appreciate
Okay,
that.
we could switch to 11 Alive, who's been going for an
Sure.
hour and 55
Bring
minutes,
this up earlier today, I'm sorry.
I think.
I have a client that's
You wanna
scheduled
do
for
that?
bond hearing at 2. I have another attorney
It starts with
coming
Keratin
in,
Matthews.
with the court's permission to sit with Mr. Stillwell briefly for about 15 minutes while I conduct the bond hearing, if that's okay with Your Honor. It's on Zoom.
Confidence Studios because
Is it
Law
okay
and
with Mr.
Crime
Stillwell?
missed stuff today. They didn't catch all of it.
He usually works with me.
And you don't need to say it twice. I see
So
it.
is that, it's fine with you if he,
So let's do 11 Alive because nobody wants to watch.
2020 alleged armed robbery of a deceased individual, Gary Holloman, from October 1, 2020. So it is not meeting the threshold of being an uncharged offense that is arising from the same transaction or series of transactions. Number two, for consideration for this court is whether or not this particular alleged evidence is necessary to complete the story of the crime. Again, we're talking about a November 30th, 2021 police chase that is not necessary to complete any story of any alleged armed robbery of Gary Holloman on October 1st, 2020. It's not necessary to have the state provide more information in order for them to complete the context of their story. Number three, for the court's consideration as adopted from the 11th Circuit, is whether or not this particular alleged conduct as an intrinsic act is inextricably intertwined with the evidence regarding the charged offense of the armed robbery from October 1, 2020. According to the court in Murphy, evidence of other acts is inextricably intertwined with the evidence regarding the charged offense if it forms an integral and natural part of the witness's accounts of the circumstances surrounding the offenses for which the defendant was indicted. So it's not inextricably intertwined from the standpoint of the November 30th, 2021 alleged this police chase where they're alleging that Mr. Huey was involved in this police chase. There's nothing about the October 1, 2020 case that involves a particular vehicle that is supposed to be part of this police chase. So there's no connection there. With respect to the police chase itself, the vehicle was not apprehended. That's number one. The chase was ultimately called off. The identity of the driver on that day was never established through any apprehension. The vehicle eluded law enforcement. There were no admissions through any subsequent arrest that was made on Mr. Huey of any admission to even being a part of this police chase, being a driver in this car. When you look at the video, there's no photos of Mr. Huey operating this particular vehicle. There's no ownership information that would show that he actually was operating this particular vehicle on that day. And the vehicle is not the subject of having been used in this particular alleged armed robbery on October 1, 2020. So the vehicle is not a nexus to any of the charges. And so the vehicle would not make it necessary to complete the story of the alleged crime in this particular indictment. So what we have here, Your Honor, is a separate alleged crime here of a police chase that the vehicle was I think it was a burgundy Nissan vehicle. It was fully dark tinted up. So no one could see inside the vehicle from the windows to the vehicle because it was fully tinted. So when you look at what we have here, we're having a separate incident that is over a year after the October 1, 2020 alleged armed robbery. And just to give the court some context on October 1, 2020 alleged armed robbery. So Mr. Huey was arrested on those charges for the October 1, 2020 incident. When he was arrested, he sat in the Fulton County Jail for a period of time, and we had a preliminary hearing on the case, probably sometime in November or so of 2020, give or take. And that particular armed robbery offense, we were able to get the armed robbery case dismissed at the probable cause hearing for lack of evidence. And then the state, they made a decision to indict the case after there was a dismissal at the preliminary hearing stage. So subsequent to that, a grand jury indicted Mr. Huey on these charges from the October 1, 2020 incident. And when they indicted Mr. Huey, they added charges, and therefore they put forth a grand jury bench warrant. There's no indication that they were able to establish that on November 30th, 2021, when this police chase was involved, that Mr. Huey was somehow running from the police because of he knew that there was a grand jury bench warrant or anything of that nature. In fact, Mr. Huey reported to court before Judge Dunaway on the indicted case and was taken into custody in court.
When was that?
That would have been in 2000, it was in December of 2021. Okay, so he shows up in the court and he has been in custody ever since. So as it relates to this intrinsic act, it just doesn't meet the criteria. Then the last step, Your Honor, I'd like to direct the court to Hines versus State. That's going to be 353 Georgia App 710. It's a 2020 case. So after the court does its analysis in terms of whether or not it is an intrinsic act that needs to be part of this case, the court then has to go to the next step of whether or not it survives a 403 analysis. In the Murphy court, the court stated that Murphy has not shown that this alleged deficiency prejudiced him, and that is his lawyer not objecting to certain evidence that was intrinsic coming in. So the Murphy court said, hey, listen, you have to show that you were prejudiced
Well,
by this coming
that was
in.
an effective assistance claim. That's a
Sure.
different kind of procedural stance than what you're talking about.
Agree, but I agree. What I'm asking the court to look at is if this court says, hey, look, I think that it is intrinsic. I do think that it somehow meets one of those thresholds.
Right.
Then the court will go to the next step of whether or not there should be a 403 analysis. Intrinsic
My
act.
bad.
And one of the intrinsic act was some information that came into to that trial concerning that particular defendant. And in that reference, it stated that this particular defendant, there was a word that was used that she maltreated or injured or harmed her children. And the court believed that that was prejudicial. In this instance, Your Honor, if this court allows this scant piece of evidence that has not been established that it was in fact Mr. Huey that did this conduct, we now have to look at, well, what is going to happen if this comes in? If you review this particular video, Your Honor, this police chase, you will hear in the on the radio inside the police car as they're driving on the radio, they're sending out this information. These are the things that are quoted. He has a history of running and he has all these warrants. That's in the video. Put some stop stakes in front of him. That's number one. Number two, he's armed and dangerous, known to carry a gun. That's number two. Number three, do you know where he lives at? And then they talk about his address. So these are all prejudicial items that are going to come into evidence if this court allows this particular intrinsic conduct. And that would prejudice Mr. Huey immensely here because these are things that are going to go to his character. It's going to go to propensity, and it's going to suggest that there's some type of consciousness of guilt.
Let me ask you this.
Sure.
Is it possible that if I determine that this is intrinsic, that that video could be played without the audio?
I imagine they could potentially play it without the audio. But there, again, there are a number of hurdles here that I would submit that do not meet the threshold of coming in based upon those three items that are required.
Right.
So it doesn't meet 1, 2, or 3. It's over a year after the October 1, 2020 alleged armed robbery of Gary Holloman. This police chase occurred on November 30th, 2021. The vehicle was not apprehended. The chase was ultimately called off. The identity of the driver on the day was never established, even by preponderance of the evidence, which would be, I think, the standard for these evidentiary issues to come in. It was called off. There are no admissions, no photos, heavily dark tinted windows. So that's my position, Your Honor. I don't believe that this one would pass the muster and the requirements to meet the intrinsic acts threshold. And then after that, we believe that it's prejudicial and should be kept out on that as well. Because as the court knows, when we're talking about the 403 analysis, it talks about and tells us and teaches us that we should not be allowing under 403 prejudicial items to come into trial that are scant.
Okay, I understand the argument. Let's hear from the state. And I appreciate you bringing to my attention that the chase was over a year afterwards and the circumstances of that. And I know that in the state's filing from November 2023, they have the date. So I'm not meaning to suggest that they were trying to pull anything over. We kind of ran through that real fast yesterday and, just kind of talked about a fleeing that was after the armed robbery that's an overt act. And I just kind of was thinking in my mind without looking at all of the words, oh, okay, this is at the same time. So thank you.
You're welcome, Judge.
Good afternoon, Your Honor. The state believes that this should be admitted as an intrinsic act. Just a few things for dates, Your Honor. So the preliminary hearing for the original armed robbery was actually in August of 2021. It was August 24th, 2021. At that point, the judge reserved her ruling and ruled either the next day or subsequently and dismissed the charges. Then in November of 2021 is when the state indicted the case. So November 8th, 2021 is when the case was indicted with additional charges and the grand jury warrants were taken out on November 15th, 2021. This chase actually occurs on November 30th, 2021, so about 15 days after the grand jury warrants were issued in this case. And Your Honor, on November 30th, 2021, Investigator Flores was actually conducting surveillance on Mr. Huey. So the notion that the police or law enforcement did not know who Mr. Huey was, they did know who he was. They were conducting surveillance on him and watched him enter into the vehicle. So they knew who he was once he entered into the vehicle. They tried to initially blue light him and pull him over. But
Was he driving? I mean, did they
He
see
was
him get
driving.
into the driver's seat?
he was driving. He was the only person in the vehicle.
Uh-huh.
They attempted to blue light him and pull him over. At that point, he took off and he, amongst other traffic offenses, went to the wrong side of traffic. They were then able to get the Phoenix air unit up to follow him. And the reason why the chase was called off, Your Honor, is because Mr. Huey drove in restricted airspace. So the Phoenix unit could no longer watch the vehicle because he was near the airport. And so they could not go any further. So they had to pull back and could not keep eyes on him. So that is why the chase was.
Okay, well, let me ask you this. So, I mean, you have evidence that it was Huey who got into the vehicle and who was driving the vehicle and that he fled when he was blue lighted. Do you have any evidence that he knew that the reason well, two questions. What's the reason they blue lighted him? Because they were about to arrest him on the grand jury warrant? And do you have evidence that he knew that, such that it would arguably be intrinsic to this charged armed robbery?
To answer question number one, yes, they were going to stop him based on the grand jury warrant. As to question number two, it appears, and I'm looking at text messages from his phone, and I don't know, all I can do is quote what I have, and these are text messages from November 8th of 2021. He says, just wait till after Christmas and the new year and turn yourself in, see what they're talking about.
All right, okay, so, and the chase is November 30th, so this is several weeks before then.
Correct. And so the case went to grand jury on November 8th. The warrants were issued on November 15th. These are text messages he's receiving, and I want to make sure. Yes, it appears that these are text messages from his girlfriend to him on November 8th. And she's saying to him, just wait till after Christmas and the new year and turn yourself in, see what they're talking about. She says it might not be a lot of time. You think somebody's snitching on you. And then his response is, I can't miss another Christmas, man. And then he goes in, yes, I don't want you to, but you can't run long either. That's going to make it worse. I'm lost. I don't know what to do. I would say to go to court, they might lock you up. He's like, yeah, but then they might not. So it appears from text messages, he was aware that the grand jury at least was going to had indicted the case. Again, warrants weren't out yet, but at least that the grand jury had indicted the case because those text messages are from November 8th
Thank you so much, Aussie
of
Tay.
2021.
More green people in the chat.
All right, well, I mean, given that he says, yeah, they might lock me up, maybe they won't, I don't think that, it's an argument to be made, but I think we're getting a little far afield of what's charged in this case. So I think I'm actually going to keep that particular incident out.
But I would just
So
argue
big win
that
for the defense.
he's fleeing from the armed robbery.
I know you're arguing that, but it's my ruling, so.
Thank you.
All right.
If that was Love, Love would not have sat down. She would have kept trying to argue. Look at her. Love is mad that she didn't keep trying to argue.
All right, and with regard to the two kind of post-indictment intrinsic acts, or arguably intrinsic acts, the stabbing in the jail and the exchange of the Percocet, I've watched the video now about the Percocet. I mean, I think that the state's rendition of what occurred is, pretty much on point. I can't hear what any deputy says, but, I don't think that there was anything particularly off about how they described what happened. I mean, I see what happens on the video. I've looked at some further case law, and how soon do y'all need to know what my ruling is on that? Because I'm kind of having the same thoughts about if we're talking about, whether these actually meet in any of the three requirements for intrinsic evidence. And then on top of that, 403, I'm just not real certain that these need to come in. I
Leave it
haven't
in the white blazer.
made my final ruling yet, but I don't think that either of these is something that the state can't try the case without, which is not the only test, but I don't think they meet that test. So just kind of FYI on that. I'm having some.
It sounds like Percocet video won't come in.
Sure.
Oh, Love is bringing case law.
An 11th Circuit case decided June 20th, 2024, United States versus Harding, Harding. The site being 2024 US app, APP, Lexus 14995.
Okay, and what does it say?
Your Honor, one second. I'm getting.
Or if you've got a copy of it, that's fine too, or I can just plug it in here.
And Harding, we do have a copy of it. We just send it to the court. And it's just standing for the proposition generally that an act that occurs after the indictment can be included.
Yeah, okay. Now, I've found my own cases that say that. Yeah, that's clear. It's not, post-indictment does not bar it from being an intrinsic act. That law is pretty clear.
Right, Judge.
And that was
if
never
I
the
may just very
argument the
briefly,
defense
let me stand up.
All right, I mean, I
We're
got it. It's
floating.
just-
I guess going back to the court's question in regards to how soon we need an answer from you in regards to that. I can't speak for the state. I'm not sure when they planned to try and present that evidence, but I would ask the court to continue giving it its full analysis, and especially in regards to the 403 and the overarching consideration as to whether or not they really need this particular piece of evidence to make out their case in chief. I don't believe that's the case, but I know that the court is wrestling with that. And I look at I don't know if I really need to look at the Harding case because we've already kind of established that that issue is not really an issue.
Right.
But I'll be happy to look for some additional case law.
Okay, thank you. Appreciate it.
Your Honor, you had
Yes.
asked the same. I'm sorry. Your Honor, you had asked the same of me. I have been pulling some case law, trying to put it together in a coherent presentation instead of just a list for Your Honor.
Okay, sure.
I definitely do want to take a look at this Harding case where it was found that the district court abused its discretion by admitting evidence as being intrinsic. So I certainly would like to take a look at that.
Okay.
So Your Honor, in terms of other cases that talk about intrinsic evidence, we would just cite the court to Jennings versus the state, 318 Georgia, 579. And I am just giving a list right now that for the court's consideration. This is not something that we have to decide right now. This particular one is not coming up at all soon. The next case is Anderson versus the state, which is 313 Georgia, 178.
And what are these standing for?
These are all regarding the intrinsic evidence and how it is that one is, how one is to look at and determine whether evidence is intrinsic, broadly speaking.
Okay. Yeah, actually, US v. Harding, I'm pulling up what I put in my Lexis research folder this morning, and that's actually one of the cases that I was looking at this morning.
Okay. And the last one is Hughes versus the state, 312 Georgia, 149. And we too will present to the court a more coherent sort of overall arching
All right, appreciate it.
argument.
Okay. All right, so where do we want to turn now? What are y'all ready to talk about?
Okay, so the reason Leah's there, she's co-counsel, but it's her argument to exclude this bad act
we
as
have
intrinsic
reviewed
argument
the,
for
we
Ryan.
haven't discussed it with Mr. Williams' counsel, but we've reviewed and looked over the Bruton motion redaction. So I'll let counsel for defendant Williams speak to them because this is, again, this is Mr. Kendrick's statement that is already in there. Portions that he is arguing are inadmissible because of Bruton. Our position overall is that Bruton specifically requires that that a defendant be directly inculpated, and at these various points, I'll let them explain why they feel like someone is directly inculpated so that I can respond, but we've reviewed them and whenever the courts.
All right, so is it the state's position then that none of the identified portions of Mr. Kendrick's statement actually qualify under Bruton?
No, there's one enumerated time area.
Which one is
where,
that?
and they have it enumerated as.
And has anybody sent me that statement? I think I asked, but I'm not sure that I received it.
Mr. Kendrick's statement? The court
Yeah,
didn't
that's
receive?
the one at issue right now. Yes. And maybe you did. Obviously,
make
I'm
sure.
getting lots of emails through Ms. Percifield from all of y'all, but I don't recall seeing it.
I'll make sure.
Maybe somebody could just send it now, since that's what we'll be discussing. All right, so which is the one that you don't have an issue with?
It's the point at which the detectives ask Mr. Kendrick, who do you think did it? And
Okay, so he's actually broken them down into little Roman numerals. So which Roman numeral are we talking about?
I wrote at the bottom my own timestamp. It's at 10004.
We're going to pause to speed read this definition of intrinsic acts. It's something that's supposed to have occurred during a transaction of something that they're charged with. But the problem in this case is they are charged with that count one, right? That big overbearing umbrella charge. But as penned by Leah Abbasi, this is what we're talking about when we talk about evidence being intrinsic. The whole defense team is arguing that these incidences, these items, things like that Percocet passing video and Rodalius Ryan getting arrested in court. The criteria here, according to case law, evidence is intrinsic if it is one, an uncharged offense, which arose out of the same transaction or series of transactions as the charged offense. Two, it's necessary to complete the story of the crime, which Judge Whitaker already said she's not agreeing that that element two is met with some of these things. Or three, inextricably intertwined with the evidence regarding the uncharged offense. This is all going to be from Brown v. State, which is a Georgia case. Such evidence needs to be linked in both time and circumstances with the charged crimes or necessary to complete the story of the crime. Further, it must pass the balancing test. So Rule 403, you keep hearing Rule 403. Does the probative value outweigh the prejudicial nature of the evidence? Also, is it cumulative? Is it a waste of time? Is it confusing to the jury? But yeah, so that's your basic 411 and your 101 on intrinsic. And again, remember, the problem here is Love wants everything to come in, and everything's related because of count one. So we'll get back into our regularly scheduled program.
4, so that would be, here it is. It's their number 8. Well, they're number 9 really, but they're number 8 specifically.
Detective Gaither mentions Mr. Stillwell, the one that is labeled that.
Right.
Okay.
Well, it's labeled, I'm sorry, Mr. Kendrick mentions Mr.
Okay.
Stillwell telling detectives who they say
All right,
killed.
that's 8. But, okay. And you agree that that should be excised?
Partially, because what happens is that this is the part that we would ask, that we specifically would argue, is not inculpating anyone. What Mr. Kendrick says is they say our crew.
Uh-huh.
And he's, in saying our crew, he's acknowledging that there is a crew. He said, because we're the ones beefing. And then they specifically say, who within your crew?
Uh-huh.
And at some point, Mr. Kendrick says, they say Shannon. That part we would agree comes out, but they didn't enumerate it exactly that way on this sheet of paper. So they say Shannon, we would agree comes out. He then says, they also say Woody, and then they say Shannon and Woody. So the part where he's naming people that they say did it beyond our crew, or people that Mr. Kendrick identifies as his crew, or, you know, in acknowledging that there's a crew, we would argue that part, we would agree, concede that part definitely comes out.
Okay, so you're saying that they say our crew isn't Bruton, but when it goes further to say, they say, whoever the they is, but they say Shannon, they say Woody, that part you agree?
Yes,
can be
I would say
redacted.
that specifically it's Shannon.
Okay.
Comes
Shannon.
out. Yes.
Okay. All right, and every other one we're going to need to look at.
And yes, I believe we should.
Okay.
The rest of them.
And has anybody come up with any case law about kind of the interplay between Bruton and a RICO or gang kind of charge? Okay.
So what Whitaker's asking here is, okay, this overarching, this bearing count one, we're dealing with RICO. Everything, Love, according to Love, everything's associated because of that count one. Whitaker's saying, well, what about case law that addresses that particular issue? Because Bruton in general is when you have co-defendants. And co-defendants, they might not be co-defendants because of some racketeering charge or gang activity. They could just be two guys, to play off Deirdre's example here. It could just be two guys or gals that decide we're going to rob a bank and we're going to plan this together. It's going to be a good time. We're going to do this. Then they get caught. Well, now when one of those co-defendants is doing their interview with the police, maybe they want to take a plea deal. They give these statements that are inculpatory of the other defendant. there's an issue because that other co-defendant cannot confront, unless that defendant, their co-defendant, plans to testify, which usually is not the case, they cannot confront the person who's accusing them in these statements. So that creates an admissibility issue for these statements. I would argue that in addition, you have self-serving, right? Obviously, if you're trying to get out of something, the things that you say, there's a self-serving issue there. It's hearsay that's likely to be self-serving because you want to get yourself out, take this deal, you're going to pin it on the other person. Or you're likely to pin it on the other person. It's reasonable to believe that you may pin it on the other person. So it's even worse that you cannot confront this person with what they said to the police. So when you hear Bruton, it's a case that dealt with this exact issue, and it leans in favor of excluding statements where co-defendants are named by a co-defendant where they can't actually confront that co-defendant on their testimony statements to the police. So let's hear Steele's arguments.
Okay, that's fine, as long as you're getting me something. They're two separate, entirely separate, but I think we can do this without knowing the answer to that.
Can I ask a question?
Uh-huh.
If I heard correctly, if the state is not, over objection, by the way, intending to play the actual recording, then it's just question and answer. So I assume they're going to advise the witness, whomever the witness is, don't mention Mr. Williams, or if you're going to mention Mr. Williams, what are the specifics? Because otherwise we're just going through something that they may not answer the question.
Your Honor, if I may respond to that, I'm glad Mr. Steele brought that up, because as we were going through these last night, there are portions that I needed to bring to the court's attention that I need the jury to hear Mr. Kendrick say. So we don't intend to play the video. Right.
Okay.
But there are portions that we would be introducing to have so that the jury hears him. And generally speaking, the overall method of introducing the majority of his statements would be through questions to avoid any implication of Bruton.
Okay. All right. Well, if there are particular portions that you intend to actually have the jury watch and listen to, if you can let the defense know which those are, that'll probably be helpful.
Okay.
That's easier. The question and answer is easy to build on.
Yeah, sure. So just let them know which of the portions. But okay, let's go through all of these if we need to, which it sounds like we need to.
Did you finish?
So do you want me to be, is there a transcript for this statement, or do I need to be listening to the audio?
We don't have a transcript of this statement.
Okay.
But we can.
But this is sped up a little bit. We're at 1.25.
I don't know how they're going to do this. Since the defense has timestamps on it that are different than what we have, I think they may have downloaded it into an MP4 format, so it may be easier for them to play it from their format because I have a specific time.
Okay. Sure. Mr. Steele, would you be able to play the video or the portions of the video that you want to litigate for us here so that I can know exactly what that says?
I think so.
Okay, that'd be great. Okay.
Yeah.
Sure.
Can I just bring up another concern on this subject? The concerns aren't limited to Bruton. I still we're talking about playing a tape where Mr. Kendrick says that other people are saying, he's not saying anything that he knows, he's not telling on anyone, but he's saying other people are saying that our crew and Shannon and Woody, and they're talking about taking Shannon's name out of it, which of course I'm in favor of, but I'm not even.
Yeah, no, I agree. That's a little weird that the state's evidence would be, well, I mean, here's what the rumor on the street is.
Right.
So I bet Ms. Rowland's going to say we're not intending to elicit that.
Exactly, Judge. The point is not, and we can tailor the questioning and the presentation of evidence to, not include.
Okay, well, I mean, I suspect the reason they're asking that now is because when we just went over that example, you thought that the only, and you may have just been saying the only part that I believe is Bruton is this part where somebody is specifically mentioned, and that's fair. But if you don't intend to use any of that portion of the tape anyway, or get a question and answer that would elicit that information, then it would be helpful if you would say that, because there's no point in us, spending time on something that the state doesn't intend to use anyway.
So to speak to that example, for instance, I might ask the detective a question that, did you talk to Mr. Kendrick about the Donovan Thomas murder.
Okay, that answer would be yes.
Yes. Did
Doug needs a closer look.
generally speaking, you know, what?
Let me ask you this. Do you think that it's relevant for the jury to hear that, you know, Mr. Kendrick said, well, here's what the story on the street is right now?
No, that part I don't. I don't think that part about, you know, the people on the street think X, Y, Z is relevant. The relevant part is his acknowledgement that
Our crew.
was beefing with them. There was a us and a them that was in conflict.
Okay. So then the only part of that then that you might elicit is that he acknowledged that at the time this all occurred, his crew was beefing with the other crew.
Yes.
Okay.
Thank you for actually.
All right. So when we're going through any of these other ones, if there's something similar, just kind of let us know that. Okay.
And Judge, we've just now sent to the court, we're sending to the court the October 6, 2015 interview. Does the court need the evidence reviewer player sent to it again?
So, no, I don't think so. But if we're going to go by Mr. Steele's playing of it that has his timestamps, I guess I'll just watch that on Zoom. Are we close, Mr. Steele?
I think that, the answer is yes, I believe. But I'm not really.
Okay.
So I guess for me, yes.
And I don't want to belabor unnecessary points.
Mhm.
We are looking at it, and I was looking at this for the purpose of Bruton.
Right. Sure.
Sure. Friendly reminder, this is on 1.25. Speed. They should have had case law ready to argue this argument. We've been talking about this for a couple days. We expected it last week already. Brian Steele filed this motion on Friday. Thank you, Leah's dad. The difference between the arguments Steele was dealing with this morning versus this case is night and day. He has to be bored and annoyed as heck here. Yeah. Or
Any other little
frustrated
discrete
here.
items we can deal with while we're waiting?
Aggravated here.
Nope.
I think love is at the cart of documents. Thank you for the super chat, Leah's dad. And you guys might hate me for it, but I actually like the little decaling on the shoulders. It adds something fun. I think it'd work better on a smoother texture pattern for the green.
Yeah, we could look at the operation planners PowerPoint, or that might be too long.
Well, they want to do the PowerPoint?
I mean, we're
This
certainly
is
going to
Fulton
have to do
County,
that.
Sherry.
I guess we can get started on that. Unless we're really close. 1 minute away. All right, we'll just hold for a minute. Or so. Or so. Come on, Mr. Kuckerberg. No pressure.
Wait, are
Mr.
they
Steele,
waiting
how'd
for
your
the
oral
records
argument go this
custodian?
morning?
The argument was good, but you know, no one remembers the argument, so we'll see what the opinion is.
Okay.
It was actually a fascinating.
Yeah, sure. I mean, we might as well fill our time somewhere.
So it's in this courthouse. It says indictment on the cover. Second page has typical indictment things, way formal reading, etc. Third page has the grand jurors in Fulton County names. Then count 1 through count 6. Former district attorney Paul Howard does hereby charge the appellee with murder. Goes like that. So I didn't try the case. I did the appeal. The Honorable Judge Newkirk granted the motion for new trial, finding no jurisdiction because it was an accusation. So the Supreme Court was very lively.
Interesting.
It was an interesting case. And then it got so
It was a novel
narrow.
argument, novel
I was
issue.
being asked, well, this is a novel issue. How would a lawyer know? You're saying it's deficient performance. How would a lawyer know? Yeah, I'm like, well, if I know, then anybody could know because I'm not that deep. So that's what I said. But it was fascinating. It was intellectually stimulating.
Interesting.
And thank you for letting me attend.
Absolutely.
And I'll drop the link. It's not commentary. It's just an archive of today's arguments from this morning.
Please correct me somebody, but this is 50s. I just
This is October 12th.
No, it's not 46.
Uh-uh. We spent all that time on the wrong interview. All right, well, maybe we can turn to the PowerPoint issue and at least start making our way through that are we ready now on the right one? Okay. So we want October 6th, is that right?
Yes.
Okay.
Hey, everybody coming in from Classy Beats. I see people saying it, but I don't see Classy. But hey, if you're here too, welcome, welcome. And then FFS, the name that everybody seems to feel when love speaks. So hypothetically speaking, aren't we all part of a gang here? We were told when to meet up by Kat. Coordination. We all showed up for our meeting. In furtherance of what? Boom, Rico.
Lawyers and tech, they just don't mix.
I hate to defend Mr. Kokomo here, but this is a lawyer issue, not a AV issue at this point.
Okay.
No, they're estimating a decision on the Supreme Court argument in State v. Riley next week. And again, it's the state that's actually appealing that. Brian Steele won a reversal of a conviction at a lower court, and I think one of the district courts. He said in here. He said in this court. So he won a reversal of the conviction, saying that the indictment was defective. It didn't name the jurisdictions, and this court didn't have jurisdiction over it. And the court he initially appealed to agreed, reversed the decision, and gave a new trial to the defendant. Brian Steele was not the trial attorney, but now the state has appealed that reversal. So Brian Steele was defending the reversal by the lower court and arguing against the state's appeal in front of the Georgia Supreme Court. So it's archived on this channel with no commentary because it's no longer on the Georgia Supreme Court website, because those things, they go live and then it's gone. But if you want to watch that, it's still memorialized.
So, Ms. Love, I know you said the state's timestamps were somewhat off, but can you get close?
Yes.
Maybe maybe we just go that way, since this seems to be taking longer than we had anticipated.
And it's weird because the court sound is off, but there's still fuzziness to the feed today that I usually don't hear. And then I see a lot of people are coming over from Classy Beats. Classy Beats also, he does stuff besides YSL trial coverage, but he's been doing a lot of YSL stuff. So you can either binge watch that or check out, he does music reviews where he reviews artist music live and the chat rates the stuff. So that's really fun and interesting. So that's Classy. I should put his name in the thing.
The defense thinks they got it and the state thinks they got it.
There's his channel
The
in the
defense
chat
has got it.
there.
All right, let's do it.
Oh, and then you are in here.
Yes.
Just to avoid the inevitable confusion, the numbers, the times that we are giving is based on the MP4 that was made from the evidence reviewer. So, and we can figure out how to convert that. But the 50 minutes, for instance, is not going to be 50 minutes on evidence reviewer.
Okay. All right. Well, thankfully, we've got the kind of general subject matter listed as well, so that'll help us.
You want this marked? I assume we have to have this marked somehow. We can put it on a thumb drive.
What we're playing now?
Yeah, but in case God forbid there's an appeal, do you want just to know what we were looking at since we were saying 50, and we could do that?
Sure. Yeah, that's probably the easiest way to do it. So I guess this is the hearing on Mr. Williams' Bruton motion.
Can we call the exhibit that?
Yeah.
Ms. Whitaker, if the state wants to see it, that exhibit.
Yes. So this will just be defense exhibit 1 to the Williams Bruton motion concerning Mr. Kendrick's statements.
And we'll have that thumb drive today.
Thank you.
No, thank you.
Oop, I broke it. Guys, I broke it because I loaded the other stream. I'm going to keep playing this, but remember, I do have Law and Crime ready to switch over once whatever Law and Crime didn't catch this morning, we can switch over to. I'm breaking it. I'm turning into
Any other people you associate with? Anybody particularly because? Oh, that ain't no question. That ain't like, that's not a whole notice. Like, that's like my rep. Like, we do shows, you help me out. You feel like, hey, bring me on to the show, just help me. Just fail both.
I think the first one was 52.
You're on the list by 49 minutes.
Okay.
And thank you, Julio Suave. I'm so sorry to hear about the goodest dog,
There should be
Julio.
Detective Gaither saying,
And very glad you didn't name it Rico Suave. I'm assuming it's a he. The goodest pupper.
third, is that the possible reason that people went after that meeting in retaliation? That's what it's just the detective asked the question. That's why I don't know if it's going to be needed because of the question, but that's the first.
All right, and give me just a little bit more general idea of what they're talking about at this point in time.
Okay,
Yeah.
Detective Dennis is in here, Detective Gaither's in here. Detective Gaither's a female, Detective Dennis is a male. And the gentleman in the in custody is Mr. Kendrick.
Yeah.
And Detective Dennis at 48, 41 is bringing up that Mr. Arnold, he's a co-indictee, pled guilty. He also goes by Duke, he is the word Duke. Regarding the issue where Mr. Kendrick was tased, he was actually chased by police and tased.
Okay.
And Mr. Kendrick then mentioned Duke or Mr. Arnold about the involvement in that, and he challenged that, but I don't think that's a Bruton issue. And then Detective Gaither talk about Duke, and then going right into whether thug is a reason that people went after them, meaning that there was this.
Why, whatever that incident was,
Yes.
occurred. Okay.
So, to me, I'm doing, I think, what the court wants, but this will never come up on a question answer because no one's going to say to Detective Gaither, I would hope, did you ask about Jeffrey Williams to Mr. Kendrick? It wouldn't happen like that, but that's the first one.
Okay, well then, maybe we can nip that one in the bud.
So there's, if Mr. Steele would not mind just letting that part play from 49
Okay.
so that we could.
It's 40 on here. When I got tased on Bankhead, it was here. When I got on Collins Boulevard, I was leaving my little boy going, so I had to help. He was in the car. It's like, man, it's like, this should go down every time. Like, man, you know what I'm saying? Jealous. Why they coming ain't talking about you, ain't talking about what folks roll, why they coming at you? So they thinking like, I'm bad at it. They think I think I'm bad. Cause I used to carry myself. I think because of other people you associate with. Probably. Anybody particularly you could pick up? Oh, man, of course, that ain't no question, but that ain't like, that's not a whole nother, like, that's like my rep. Like, we do shows, he help me out. He said, like, hey, bring me on, say shows, just help me, just sell both. I don't know why, would you feel like I took your part, your spot? A lot of people feel like, I took their spot, you know what I'm saying? But it's not, I don't get around on even try to take on niggas. I'm brother, man. I got whatever I got going on, you just spot. Yeah, we're grown, bro, that's facts. Grown man,
It just tripled his bald head.
Bro, you know these folks, right? They spot. Right. I think about it, look at it for other people's perspective. No, I don't think that may be what it is. Yeah, but everybody.
Okay, so Your Honor, there's no part that I hear Mr. Williams' name mentioned in there.
Can't really hear much though.
I didn't hear Thug or Mr. Williams' name mentioned, so I don't
blame Love on this one.
Okay, well, let's just ask it this way. Do you have any intention of who's this coming in through?
There would be either Detective Thorpe, probably Detective Thorpe later on.
Is he even in this?
He's right there in front of you. To the left.
Oh, okay. I thought you had said Dennis and Gaither.
Dennis and Gaither are sitting in front of Mr. Kendrick. And Detective Thorpe is his
also
right.
in there.
He
Okay,
is.
all right.
Yeah, three.
So, I mean, you're not going to ask Detective Thorpe if Gaither asked if Williams was a reason why.
No.
Okay, so that would be one then. This example would be one where you could say, we don't intend to ask that anyway.
Okay, so we do not intend to elicit or ask whether the defendant Williams was.
All right, well, let's
Whatever.
circumvent spending the 5 minutes listening to it if you know you're not going to use it anyway, okay? That would be super helpful.
Please.
Okay, next.
But so when, again, this is one of those them, us, we, them situations. It is simply not one of those situations where we would be saying, you know, are they coming after y'all because of Thug? Are they coming after you because of we wouldn't be eliciting anything about another defendant. But if Mr. Kendrick is talking about us and a them, like he is in this circumstance, they want to take my spot, things like that, then we would be putting that in. The reason I was saying we're looking at it in terms of Bruton is because if he's not talking about a defendant and he's not saying that person's name and inculpating him, then it's something that we will likely use. If there's a point at which I know that I'm just not going to even touch it, I'll do as the court has instructed though. If, and say, no, I wasn't even going to ask that anyway. It doesn't do us any good.
Okay, so then what I hear you saying is that while you're not going to elicit that somebody asked if Mr. Williams or Thug might be a reason people are after them, you would maybe ask about some part of Mr. Kendrick's answer there, which said something about whoever they is, wanting to take my spot.
Yes.
Okay.
And that we contend is not Bruton.
That would not be Bruton. Okay. Next.
5239, and it should be Detective Dennis speaking. And he talks about Mr. Shannon Stillwell. He calls him Shannon.
Okay. And then you wouldn't be able to mention Mr. Stillwell. Is there some part of this little bit? Go ahead.
I'm sorry.
Go ahead.
So he does not say that Mr. Stillwell bought the gun. He does not say anything that directly inculpates Mr. Stillwell. And my understanding is that Bruton does not prohibit the mentioning of.
Let me just hear it. I see this is the way it's going to go.
Troll your courtroom then,
Playing for
maybe.
52-14.
Hylton just looked like, really? Again, Love? It is so funny. They're like tripling the squirrel brain head with the glitch.
And this
Every
is before
time his
buying
head
the
gets
gun for what? What are we talking about here?
I'm sorry.
Anybody?
So one of the he was shot with a gun in October and one on January 28th, and they're talking about the guns that he had in those situations. January 28th and October 1st. of 2015.
All right, and these are overt acts, or are they?
Yes. One is an intrinsic, January 28th.
All right, go ahead.
Well, I disagree. True. But I mean, like, the first man, like, fuck these big ass nuts. But the second man, like, I got to ride with somebody gonna protect myself. You feel like, right? How long is that? Like, of course, Like, you better after you spoke, Shannon? How about, like, before all this stuff happened?
I don't think you can stop it. That seems pretty inculpatory of another defendant. Did you buy it after you talked to this person? As if, no. Don't.
Leave that part out.
That was out. Okay.
I think she said, let's just play it.
It's right after that, but it's the same thing, Your Honor. Now it's Mr. Kendrick speaking about Mr. Stillwell. He includes Mr. Arnold as well to clarify what Detective Dennis said about the gun. And that's at 52:51.
And Judge, just to go back just a bit, he wasn't saying that Shannon told him to buy the gun. He was orienting Mr. Kendrick as to a conversation with Shannon. It wasn't saying that Shannon tell you to buy the gun. So it wasn't inculpating Shannon. I think that it may be helpful to hear before the part that they started on. It's like, did you talk to Ms. Hylton? Yes. Did you buy the gun after you talked to Ms. Hylton? Yes. But it has nothing to do with Ms. Hylton told me to buy the gun.
Well, I mean, unless you can make it really clear that all that's doing is orienting him in time to something, but to have the question be in front of the jury that is, okay, you had this gun that you got in trouble for. Did you buy it after you talked to one of your co-defendants? Okay. Just seems too Bruton-ish to me to permit. And the state ought to want to try a clean case. So
that's fine. That
would not be clean.
Okay.
Go ahead. Next one.
This is 52:50. You should back it up. This should be Mr. Kendrick. Mr. Kendrick bringing up Mr. Stillwell and Mr. Arnold about clarifying the answer that you were just discussing, although I think that's out, actually. So it's really 54 minutes we can go to, and that should be Mr. Kendrick. And he mentions Mr. Copeland, Duke, or Mr. Arnold, and Rich Homie Kwan, Mr. Lamar, and Mr. Stillwell, and he doesn't want to be associated with them. So we ask that Mr. Stillwell's name be redacted.
All right, well, I'll listen to it. Okay, give me enough so that I can hear the context of why he said it.
See, that's why I be a man. That's why I pull up it. I don't I be on more of a defense. It's like, if I don't got it off, I would stay asleep. Right? It show you that, like, I'm so much a good permanent friend, that way it hurt me. You know what I'm saying? Well, I'm in shit. This like it. And he get to go with it. Like, he get out there, like, me, and I let him look at shit. Yeah. So it's like, God damn, bro. Like, it makes me look at my loyalty in my country like, you can't be bending your back for a lot of these. And that's why I feel that from the people y'all just named. Right. Which was my original crew member, like, the people I was riding with. That's why I feel that. So it's like, I ain't getting 100% from none of them. So it's like, y'all ain't gonna be getting my 100%. Who are you speaking of when you said it? From Shannon, who else? Dude, everybody here, going, like, everybody that all that have been together at once, like, all that not rock, joke on all that. So it's like, once I figured out, I was like, I don't want no part of the feel like. So it's like, what are you gonna?
All right, I mean, he says some about being regular crew members and not getting 100% from them, and then saying them by name. I think that's a Bruton issue. So, would you understand that if you do intend to ask about this?
Not having to mention Shannon's name.
Correct. Okay. All right.
The next one, Your Honor, should be around 58:10, and of course, they'll announce the time to orient. But this is now Detective Dennis's voice, who's mentioned Mr. Stillwell swung first outside of Club Crucial. That's the fight that you've been hearing about on the 6th day of January 2015.
Well, I might not even need to hear that
Mocha
one.
has a new
just
channel.
before we go to that one, I just want to make clear, Mr. Stillwell's name is the only one that is on trial that Mr. Kendrick mentions at the last little clip. Mr. Copeland, Mr. Arnold, Mr. Lamar, they have those names listed in their motion. I'm sure they don't intend that that is a Bruton violation. They're not on trial. So we would believe that it's okay to mention those names. But
Does the defense want to be heard at all on that, or what your position is on that?
I'm still researching, Your Honor,
How did y'all redact this indictment?
we've been asking for that to be redacted. It's been denied.
Well, what got read to the jury at the beginning?
Everything except, I think, overt act 26 maybe was redacted, maybe 2 overt acts, but I have to check my notes on which ones. Otherwise,
It's
the
a great
entirety
sign. Whitaker
of the
is
indictment was
curious
read to
on
the
this.
jury.
Including the names of all of the co-defendants that are not on trial?
Yes, every one of them.
At the time, they were on trial. So severance happened during the course. So when we first had the indictment read, it was more than just the 6 that are
Was it
present in the
all,
court.
whatever, 19 of them?
with the exception of maybe the ones that hadn't yet been apprehended.
Yeah, so everyone was here except for,
And everybody at that point in time was on trial together?
yeah.
I mean, it's been a long time.
Except for the ones that pled and a few that were not apprehended, yes.
The ones that had not had attorneys, Mr. Garland, and some that had not been apprehended. So I think 6 that weren't.
So Mr. Kitchens is indicted. He pled guilty around Thanksgiving of 2023. The jury first came upon us January 4th, 2023. So I made a mistake. Mr. Kitchens pled guilty under Alford in November of 2022. Mr. Arnold did the same. Mr. Sumlin did the same. Mr. Stevens did the same. Mr. Murphy did the same. Mr. Sledge did the same. Thank you. And I should look at the indictment for more. Mr. Garlington never had a lawyer, so he was already removed. Mr. Wani Lee pled guilty around the same
Who
time.
was that last one?
Mr. Wani Lee, L-E-E, and Wani is W-U-N-N-I-E. So, the stage, I'm sure it was a miscalculation, but these people were all included in everything in the indictment, but were not on trial before the veneer panel was first put upon us. And if I left somebody out, Mr. Eppinger was with us for jury selection, then he got, something happened, because he got removed after that. So he was in a different category. Mr. Blaylock pled guilty after the veneer panel.
But Mr. Blaylock has not pled guilty. Mr. Blaylock was severed as well. So I believe I said everyone who had not pled and not been arrested was present. So there were individuals who were severed subsequently. So Mr. Blaylock was severed after the jury was impaneled.
That's true.
Mr. Dorsey was severed. Ms. Eppinger was severed. Mr. Mender was severed after the jury was impaneled.
Right. So the people I mentioned pled before the veneer panel was read the indictment. And I'll look at the indictment. There may be a couple more, but that's my memory.
Get love in Hylton. Now this is interesting because some of these, Rodelius Ryan is still here, but some of these intrinsic acts they've argued about so
Mr. Murphy
heavily
was severed
really
before we
focused
did.
on those.
He was
other
apprehended, I think,
co-defendants.
afterwards. So name was read to the jury, but he was never with us.
So if they had not pled and they had been arrested, they were all on trial. And so obviously those names were read. Were the names of the people who hadn't been arrested and hadn't pled been read? Were they read? Yes. So everybody's name was read. Okay.
That little giggle was a different type of giggle.
And I don't know if there were any counts of the was every count of the indictment read, even if it was only against somebody who had already pled?
Yes, Your Honor, because I think it was pre-recorded, and so everything was read. I think it's your question. Yes.
Okay.
So the one thing they prepared in
there any
advance, they
objection
should
to
have
that?
actually modified.
Okay.
When the court says objection to that, and there's a yes, get clarity, because on the yes,
I mean, honestly, at this point, that'll be a motion for new trial issue if it gets to that stage. I'm just trying to figure out what this jury has heard. Y'all would not intend to send out an unredacted indictment if we get to deliberation, right?
we had actually talked about redacting the indictment. I think we were actually.
Okay. All right. Well, good.
Look at Hylton's face. Look at
I don't think an
Hylton's face.
unredacted one should go out. All right. Anyway, back to what we were doing. So I mean, the question was, with regard to people who are not on trial here now with these 6, is there any kind of objection to those people being mentioned?
Yes, so I'm finding Bruton under conspiracy
Yeah.
and directly impact, and that's what I have to get to.
Okay. All right. Well, why don't we circle back on this one then? Because that obviously what the law is will determine what the answer is. So it's definitely out with regard to naming anybody on trial here other than Mr. Kendrick, but with regard to anybody else, TBD, depending upon what the law says about that.
Yes, Your Honor.
Okay. So y'all get the next one lined up. Let me jot myself a note on that.
This is crazy to think we just went through all these intrinsic acts where these other people are pictured, and the jury has heard counts charged against those people
Okay, I'm ready for the next one.
that they may have been framed to consider. But they're not the ones that are currently enjoined to this day. And Love was still trying to get those intrinsic acts and these statements, really focusing on them, making them look bad in here.
10205, so Mr. Kokomo, you'll orient us earlier on what's going on here, Your Honor. Detective Gaither is asking, this is at 10055. But then after Woody got jumped, you know who Woody is? Who shot up the studio TIG? Mr. Kendrick states, I don't know. Mr. Gaither said, I heard your crew shot up TIG after Woody got jumped on. There's a discussion of where is TIG? Then Detective Gaither says Metropolitan, like over there by Thug Studio. Mr. Kendrick asks, where's Thug Studio at? And then they talk about that location. They talk about YF and Lucy. And then at 103, Detective Dennis say, you still on Bloody J when he got locked up. And it goes on to that event. And
So is this just because Mr. Williams' studio is mentioned to orient people to where things are?
well, at 102, it's just about the studio, but I was targeting the RICO conspiracy. So I was targeting the, this is where, actually, I'll withdraw that because
Okay.
it does not mention, I apologize.
All right, no problem.
All right, number 105:19, 1:05:19, Detective Dennis mentions Mr. Williams' quote unquote girl regarding a shooting, supposed shooting of that event. And that is, it's 104:32. Detective Dennis states, didn't you catch them down bad? That's a reference to Mr. Kendrick's music. They laugh. It's a verse in a song. And then Detective Dennis says, so who shot up Thug's Girls event? Or did you hear about that? And Mr. Kendrick says, I don't know. That's my first time hearing about it, so I wanted that excluded.
What's the response?
That doesn't, number one, evidence of that has already come in from Dennis, but number two, that in no way inculpates Mr. Williams in anything because it references
His
him as
girl being a victim.
right.
Okay, yeah, I mean, I don't think that's a Bruton issue.
So my issue with that then would fall back on a different issue then. What's the point? The answer is, I don't know anything about it, so we're now just using
So
the
now we have
question.
a relevance objection.
Can we just?
No, we'll do them all at the same time, so. Don't.
I don't have a problem not having him since he doesn't know anything about it, keeping that part out. He said, I don't know
Okay.
about that. I don't have any problem keeping
All
that
right,
part
thank
out.
you.
Next is 1:08:40. And this is the part you heard earlier that may be stipulated to. Mr. Kendrick mentions Mr. Stillwell telling detectives who, quote unquote, they.
Right, and on that one, what would be permissible to ask about is that at around this time,
They were beefing
our crew were beefing with
them.
the other group, but not anything about the
Your love in
rumors
the
or anything like
background.
that. So that one I think is clear.
Us
Okay.
versus them.
Next one.
The next, Your Honor, will be it's really the same flow, but it's 1:08:51, so it's only 11 seconds later. And Mr. Kendrick, mentions Mr. Copeland sharing that he was tied up with Mr. Stillwell, and specifically, and then Mr. Kendrick identifies a photograph 8 seconds later of Mr. Stillwell. Then Detective Thorpe mentions Mr. Stillwell and clarifies that the word is that Mr. Stillwell and Mr. Copeland killed Mr. Thomas. And Mr. Kendrick speaks to that.
We don't have any intent to bring that out.
Any of that?
Right.
Okay.
Okay. The next is 1:11:30. And it's Detective Gaither mentioning that Mr. Stillwell is the person that whoever everyone is, brings up related to the murder of Mr. Thomas.
And this falls in with what we initially said, that when they were talking about who they said killed Donovan and bringing up Mr. Stillwell's name, we have no intention of doing any of that.
Okay.
Okay.
We hope.
The next one is 1:13:44. And it's Detective Thorpe, I believe.
All right.
And he says, people talk to you in the city, all put you four involved in the murder of some kind. Mr. Kendrick denies it, says they are lying. Detective Gaither says, you think anybody going to tell the same story? Mr. Kendrick asks, what did they tell? Detective Gaither said, I heard you was in the car. Mr. Kendrick said, what car? Detective Gaither said, the Infinity rental from Thug. And then Mr. Kendrick said, no, I wasn't. Check whatever, my phone, whatever you want to check. And then Detective Gaither says, we did, it was said a whole lot. And then they go off on that. So I was objecting to Mr. Williams or Thug you mentioned.
Your Honor, that whole, all of that colloquy is part and parcel of them talking about who people said killed Donovan Thomas. Anytime we're talking about any of these defendants being rumored to have killed Donovan Thomas, the state has no plans to get near that part. Now, Mr. Kendrick denying that he was in a rental by Mr. Williams, we would proffer that type of information because it would not inculpate Mr. Williams.
Yeah, I agree with that. I mean, I think it's already in evidence that Mr. Williams rented an Infinity, right?
Yes.
And up for dispute whether that was involved or not.
Right.
But saying, the Infinity that he rented doesn't inculpate him directly. So that I would be okay with. I mean, I don't think there's a Bruton violation if you ask or get an answer that talks about the Infinity that Mr. Williams rented or that Thug rented. Okay.
The next, and I'm skipping based upon what the state just said about that whole colloquy.
Okay.
So it would go to 1:18:31. And that's after 1:17:35. Mr. Kendrick reaffirms he has nothing to do with the murder of Mr. Thomas. And then at 1:18:25, Detective Gaither asks about NARD, NARD, and DUWOP, DUWOP, where they are now. And Mr. Kendrick explains he's almost questioningly locked up. And then the target event, Your Honor, is Detective Gaither asked from January 10th until today, how many times do you think Shannon been locked up? We'd like that redacted.
My apologies
That's
for leaving that out.
prejudicial.
I would not put that in.
Okay.
Good. Yeah, that's obvious.
The next one,
The part about Mr. Stillwell being locked up, the other part, yeah.
Yeah.
the next one is 1:21:25, Your Honor. And at that point, Mr. Kendrick had shared with the detectives that he went to Miami after January 10th. Detective Dennis asked who all went. The answer by Mr. Kendrick is everybody. Detective Gaither said, who is everybody? And then Mr. Kendrick starts naming little d, everybody. And then Detective Dennis points to the photograph of Shannon Stillwell. Mr. Kendrick says, yes. Says, yeah, actually, Y-E-A-H.
Okay.
So that's the part that we were taking out, the picture and the point.
Well,
This is just him saying, here's who all went to Miami.
Yes, immediately after
Doesn't
the
inculpate anybody directly in anything. It might be argued to be a part of the evidence, but that wouldn't be a Bruton violation.
Okay, we're just raising objections then, if that's okay. And when I say okay, I'm not waiving anything.
I understand.
Okay, I said okay, but thank you.
Yeah.
All right, the next one is going to be included. Did Thug went? Was a question by Detective Gaither. The answer is yes or yeah, so I assume it's the same ruling.
Yeah.
The next one, Your Honor, would be, and I assume it's covered by your ruling. Detective Gaither asked Mr. Kendrick, how long did Mr. Williams stay in Miami? So I'm assuming it's the same ruling. So I'm moving on from that one.
Okay. So the one about before that 1.23.06 about Mr. Stillwell getting calls.
Yes, I should have included. I skipped that one accidentally.
And what'd you say, Ms. Love?
I'll let the court decide on that. I'll let the court hear that, because I didn't count that as inculpating, because everybody was, what he's contending is that people were calling, but I'll have to hear that part again.
Okay, let's just hear that part, because I'm not sure what it says. And
Start at about 1:22:40 if you can, Mr. Kokomo. And what it should say is, it should be Detective Dennis asking about what conversation was like on the way down to Miami. Detective Dennis specifically, I believe, said, Your Honor, the ride down had to be some type of, just like you just said, like when Duke got jumped on, people started hitting your line. So you all started to get worried. And Mr. Kendrick said, it wasn't on my conscience. And then in there, they talk about Mr. Silva was probably getting calls.
all right, let's just see.
Everybody was sitting there like, yeah, that was just stoned with it. Like, I did my own heart.
Right, but what I'm saying is, the ride down had to be some type of.
I don't know. I didn't know
Because
anything.
just like you just said, when Duke got jumped on, people started hitting your line. What's going down? So y'all had to start getting word that these names are out there. Nothing just got killed.
Yeah, but they're like, he went, they probably got getting like calls and saying shit like they think with him, but he wasn't on my country or folk might call me. Like, yeah, you know what I'm saying? They went.
But if they're your people, it's almost like you're guilty by association to an extent where if they're not.
We wouldn't have any problem taking that whole last 2 or 3 sentences out. Like, they were probably getting calls thinking it was them, and the dentist saying, it was your people, you guilty by association. Like that, those 3 or 4 lines, we don't have any problem coming out.
All right, does that cover it?
Yeah, Mr. Kendrick, I'm sure it covers it. Specifically said Shannon, so I'm assuming it covered it too.
Let's make sure.
Yes,
Okay.
yes.
Okay,
Excuse me, Your Honor. Can we take 5 minutes before we continue down the list?
sure. Yeah, that's fine. Let's take a quick break.
Thank you.
Sure.
Okay, so we're gonna skip this. I do want to shout. I do want to shout out Mocha. Mocha started a new channel, and that's rough. Sometimes it feels like you're in there talking to yourself. But her first video that I see recently is called YSL Rant. So let's show Mocha some love. Let's get her a bit of an audience going. That gets that motivation going, and you'll get something in return. You'll get to hear a YSL rant. And who in this chat does not love a good YSL rant? So there's Mocha there. So thank you so much, Mocha. So you said, it's Kanisha. I'm starting a channel. Thanks for the inspiration. This case just makes me so annoyed. I have to rant and inspire ranting. Absolutely. I totally get it. And Mason Martin, thanks for the super chat, says, wit and steel chose violence today. So we're going to get ahead. I think we have some more of these videos. Do they come back to the video at all? Because I know most people said stick with the volume, but maybe that's because the videos are hard to hear. How do you guys feel about when the video's done, we switch over, we get some closed captions? Letting it be a democratic process. We will do Law and Crime again tomorrow. Hopefully they have their audio fixed. Who knows what demons have been in these AV systems today. And I wonder what Love is Whitaker's looking at. But some of that stuff is crazy. And let's do a little chat vote. Put a 1 in the chat if you think Love, any of those things that she said, we don't intend to bring that in, or yeah, we are not going to bring that in. We plan to keep that out. Put a 1 in the chat if you think by accident or on purpose, one of those things will suddenly play in front of the jury. Put a 2 if you think it'll all be gravy. And oh no, has Bruce been sick? That's sad. Because I know he was absent, I just figured he had other stuff to do.
The next one, Your Honor, we are going to, I believe it's included in your honorable court's ruling. It's approximately 1:25:39. Detective Gaither asked Mr. Kendrick how long Mr. Williams was in Miami, and the answer is a couple of weeks. So I assume that your court said that that's not inculpatory, so I'm moving on.
All right.
The next one is, it's a visual. So if they're not showing the video at this, it won't matter.
All right.
But Detective Dennis points to the photograph of Mr. Stillwell and says he's all about that action. And they're talking about shooting people. They're talking about violence. So you may have to hear that, but and see it. But we would object to that.
You're not going to use that? All right, states agrees, well, they don't agree it's Bruton, but they're not going to be using it.
Okay. The next one is Detective Thorpe. It's a 1:33:55. Mentions Mr. Williams and how Detective Thorpe heard that people went to Mr. Williams' home after the killing of Donovan Thomas. You may have ruled because of the way you treated the rental car that that's not Bruton, but that's what I flagged.
All right. Do you think I need to hear it, or is it pretty much?
That's pretty much it.
Okay, yep, that would not be Bruton.
The next one is approximately 1:43:20. And I'm not so sure this is covered by Bruton, but Detective Gaither asked Mr. Stowell if he drives a Volkswagen, but I flagged it. But if that's not directly inculpatory, I understand that. But that's what is said.
Okay, and this is just as Mr. Stillwell or his nickname drive a Volkswagen, yeah.
Yes. The next one is 1:47:18. Detective Gaither asks what was in its, I say Mr. Williams, but Thug's demeanor when he pulled up to the McDonald's, and Mr. Kendrick says he cannot speak on that, so I assume that that's not under this
Demeanor
court's,
sounds like an
court's ruling.
element.
Anything would deal with Bruton, so I'm moving on.
Okay.
And if I'm waiving something,
No,
you say no.
you are correct
Okay.
in your assumption.
And then the next one is 1:48:07. Detective Gaither asks, so that night, meaning the killing, you didn't meet up with Mr. Williams, and then ask the same for Mr. Stillwell based upon your honorable court's ruling. I believe that one we're going to skip. And if I'm wrong, please tell me I'm wrong. But
Does, what's the state's intention with regard to anything you might ask about that?
Given his alibi, we would, well, I don't know what it's, we would probably be
Asking that? Okay, well, yeah, I mean, I think that would be okay.
and then the next one is well, it's really the same, Your Honor. It's clarifying the same thing. You didn't meet up with Mr. Williams or Thug and Mr. Stillwell, so
Okay.
that's it.
Yeah,
That would
same.
cover the entirety. Now, that's just for Bruton, but again, I will send to this honorable court, and there are cases on a RICO conspiracy, a conspiracy, and Bruton.
Okay, I will be on the lookout for that and the state's position on that also. All right, so we can circle back to going through the evidence that's going to come in with the next few witnesses, including Mr. Sprinkle. If y'all are ready on that, we can move on to the wiretap evidence that the state intends to use. We can,
the PowerPoint maybe is.
I mean, we can do the PowerPoint. Would the wiretap evidence come before the PowerPoint?
No. it would
Okay,
come after the
PowerPoint. All right, yeah, we can look at that. So everybody should have the kind of revised PowerPoint, I guess, that the state provided over the weekend, I think.
We display it on, you're on the court allowed, you display it on the screen so easily run through it.
Yeah.
And Your Honor, if I may just turn my back, you will give a thumb drive to Chris Sprinkler. Yes.
And so what the state sent over at this point would be, y'all have taken out everything that you don't intend to use. So the hope is for y'all that all of what you provided is usable, and we'll sort that out. All right. Yeah, so if somebody wouldn't mind, I guess, just giving us kind of a slide by slide. And I
Because we
don't, I
can
mean, I
kinda
don't
see it
know
on
that it
the
needs to
screen.
be displayed on Zoom as long as we're all looking at the same thing. That might be a better approach. So let's all just get our email that sent it over and open it up and look at the slides on our personal computers or laptops.
It was an email Sunday at 9:15 p.m.
It's visible a little bit on Love's screen. A little bit.
It was sent Sunday at 9:15.
And was it a Dropbox link or was it an attachment?
It was an attachment with a PDF.
Okay, right. Okay. All right, is everybody ready? Everybody got it up? Yes, yes, yes. Okay. All right. Slide 1, I don't see how the state could possibly need that slide.
No, that's not. No, I mean, it's not. Just, no.
Okay. Slide 1's out. Slide 2, this is just sort of,
These are
Take it out on her own.
identifiers that APD has identifiers that APD has identified, and
all right, hadn't there already been testimony about that?
there has been testimony about snakes and tattoos and red flags. Yes,
Okay, so that one's out too.
if you say it is, it is.
Huh?
And
I mean,
just to make sure we're all on the same page, what you're referring to as slide number 2 is the picture that has an arm with a
Yeah.
tattoo. Okay.
Yeah.
Which also, coincidentally, is the second slide in the attachment. That's what I'm going by.
All right. Just didn't want to make sure you weren't
All right.
on the title page. And
Okay.
we're on the same page,
All right.
literally.
Okay, good. All right. Slide number 3. What's y'all's argument for needing that?
Okay, we can.
Because we've still got some language on all of this too.
So we can take out, we can take out all the language.
Mm-hmm.
We take out all the language.
Okay.
Yep. Can you take that aside? John, may we be allowed to remove the Mondo board, the IT department?
Yes, that would be wonderful. We're not going to use it, so out it goes. So y'all go ahead and, yeah.
Not right now.
Okay. What about these 5 pictures?
So the pictures, Judge, are just, as he's talking, he would,
All right. So who are I see we've got
Defendant Williams,
Mr. Williams, Rich Homie Kwan.
Birmingham.
Are there pictures already in evidence of
Yes.
those 3 people?
Yes.
Then use the pictures already in evidence. How about the bottom 2? Who are they?
Donovan Thomas is on the far right side.
Is there a picture of him already in evidence?
There is a picture of him in evidence.
All right, use that. What's the middle 5th one?
And this is Defendant Williams. And pre the gang, pre the dispute, the war,
Okay. I mean, is there a picture similar to that if he needs to identify people or a group of people he could use?
Yes. Numerous.
Tell him, Keith.
hold on one second, Your Honor.
Hylton.
We have videos of the groups of
All right, so
persons
you could do
together.
a still from a video.
We
Okay.
can.
All right, how about slide 4?
This is just, Your Honor, and our position regarding the displaying of these pictures is that they're demonstrative as he's talking about them. Of course, they've seen Mr. Copeland for what feels like ever. So they sort of know who he is. They haven't seen as many pictures, just face shots of Mr. Watts. So they're not, we would just put forth that there's,
Is there a picture of Mr. Watts in evidence?
Yes,
but
there
they're
is.
demonstrative.
Looks kind of similar to this.
So the reason that we would ask that the PowerPoint photos be allowed to be kept in is they're demonstrative. These are clear face shots of who they are talking about. There's nothing that is inherently or substantially more prejudicial due to the cumulative nature of these photographs that would cause either defendant to be in danger of being convicted of something or on something other than proof of the crimes we have listed in the
Are
indictment.
they going to, for some reason, be talking about Mr. Copeland and Mr. Watts together, that they're like,
Yes.
it's going to be crucial for the jury to see here's Copeland and here's Watts?
Not crucial,
Lots of
but
shell
he will be talking about a specific interaction, specific.
Okay, well, he can talk about that without this. And if you need to have the jury reminded, oh, this is what Mr. Watts looks like or something, just use something already in evidence. All right, what's this picture of some fence?
The gambling house that
Do we have pictures already in evidence of that?
knew.
Okay, and this one's fine. Slide 6. With the stack of money and obscene gesture.
Hold on. Well, that's Mr. Copeland, and it was that stack of money and that flashing of it at a club that led to the conflict between him and Mr. Watts. So
Why is she so giddy?
We've also got video of him doing exactly the same thing.
we don't have that video.
Yes, we do. We've had a video.
All right, well, don't talk over each other. Do you know what exhibit number that is?
Your Honor, we initially entered the video in June However, that was after 3 o'clock. And so we did not enter it again this time around. So I do not believe the video is an evidence. I believe that was after 3 o'clock.
Actually, good point there, because we do need to make sure when we're finally reviewing what evidence is in and out, that we make sure that everything that was entered in that little period of time is unentered, if you will. So, okay, this one's fine. He can use this one.
Can I inquire as to exactly what the relevance would be of showing a picture of Mr. Copeland holding money and flashing the bird?
Well, I mean, they said that was what had started a beef between him and Watts.
The flashing of the large sums of money.
Not the flipping the bird.
I mean, I don't.
So you don't know what started it.
The flipping the bird, I mean, it wouldn't have,
And she didn't really say that's what started it.
Relevant
It was the
because
same
it
night.
shows Mr. with that huge stack of money that we're talking about, and it makes,
Is this the night of?
it's,
Or is this
you
just
say the night of, not
the
John
night-
and Thomas.
No, the night that the beef starts between he and Watts.
No, Your Honor, it is not.
It's just an example of him with a
Flipping the
bunch of
bird
money.
and holding money.
An exemplar. Good
It's-
word.
I think it's January the 8th. The 6th, January the 6th. So it was the night, it was.
Okay, and for clarity here, earlier in the chat I said, hey, should we switch over to Law and Crime? They have closed captions, but it sounds quieter. It sounds like the whole feed for the media pool just got quiet around this point. So if you guys want to redo that vote with new information that all of the streams are quiet and you'd prefer captions, let me know in the chat. We'll switch at the next break. But it's the feed. This is still full volume.
It preceded it. That's the night that the fight started that led to the arrest of, I think, Mr. Kendrick and Mr. Arnold the first time when Bloody J was punched out.
So this is a picture from the night that, it all got shot up or
I'll-
something?
I'll confirm, but that's what
After-
my understanding, that this is January the 6th.
I don't know January the 6th. Where does that date come
I don't
from?
know. I don't know. Maybe they know what he was wearing to the
It's
club
the
that night.
detective that gave it to us, so.
My recollection is that he had different clothes on the night when he was flashing the money than he does in this particular picture. I do not believe.
So do you have any kind of picture from that? I mean, if you can confirm it was that night,
We
that's
will.
fine. Otherwise, it's just an example of, hey,
Well, not just.
here's what we mean about flashing money.
No, the large amounts of money.
Right.
I think during the course of the interviews that the jury has heard, you hear them talking about a very, very large sum of money.
Right.
And, one might argue or wonder, what kind of money, how much money did he have access to that kind of money? Him having a stack of money like this. I mean, it could have all been ones, but even ones would have been a lot. I mean, I'm just saying. So the relevance bar is, of course, as the court knows, is a low
Yeah.
bar. And the fact that he's sitting there with that.
Okay. Well, he also is flashing the bird, though, or flipping the bird. So that's a little bit offensive, I'm sure, to some of the jurors. So maybe why don't you find out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? Or to some of the jurors. So maybe why don't you
There we
find
go.
out whether A, this is that night, and B, if there's some other photo already in evidence with him with large stacks of money, okay? So we'll revisit that when we.
It is their logo is gonna block
Yes, ma'am.
the PowerPoint, but we have captions to hear what they're saying.
Slide 7.
Shout out to their AV and tech issues today.
This just shows a couple of the, the Metro, but there's been testimony about the Metropolitan, right?
TIG studios that
Right.
Mr. Copeland is alleged to have shot up, or believed to have shot up.
We've had a number of crime scene photos of the Metropolitan. So there are a number of photos of that in already.
So it doesn't, there's nothing, if Detective Dennis is talking about this, putting it up doesn't take extra time. It just orients the jury as to what he's talking about. So it's a demonstrative aid that orients the jury, that is helpful to the jury, that is substantially similar to that is exactly what he's talking about. So there's nothing that should preclude
Okay,
him
and
from showing it to the jury.
TIG is who's,
Think It's a Game
Right,
is the company that Rich Homie Quan was under, that Think It's a Game Studios is inside
Right.
that building right
okay.
there.
This one's fine. All right, moving on to slide 8. So this is several pictures of Mr. Thomas. We definitely do not need the Club Crucial, We'll Always Remember You part of that.
Okay.
And
And remember, this is what they redacted.
the language about whether he's a high-ranking member of a rival gang, I mean, that's,
It can come out.
thank you.
But yeah.
I know it's asserted that he is, but this sets it forth like
Yes. it can-
fact, and
it-
that's for the jury to determine.
Yes, Your Honor. I'm just trying to X over everything.
Okay, so,
Did you have something else?
I mean, those three pictures basically of Mr. Thomas and Mr. Thomas and some of his
Brothers, family,
Well,
whomever.
I would object to the pictures of,
greed.
well, the pictures period. I mean, I don't know what the relevance is and what the jury would need or how this would aid the jury in understanding any testimony from Detective Dennis to show pictures of him and various individuals just standing around.
So, do you want to elucidate us on that?
Yes, we can take.
Okay, so they won't use that one. All right, slide 9.
So slide 9 shows just the type of,
Are these actual posts already in evidence?
no, we did not.
Okay, well, if they're not, then I would think if you throw these up, that is more than demonstrative. So if you want to enter those as examples, we can talk
Okay.
about that, but
Okay.
otherwise he can just testify that here's what happened on social media after the death.
Okay.
All right, slide 10.
Donna?
Yeah.
I would be objecting to Detective Dennis saying this is what I saw on social. Okay, you understand that?
Okay.
Would
and
be hearsay.
because- And how would, well, no, what he saw on social media, he saw on social media.
If he's going to say, I saw on social media and someone posted the following, I'm assuming that's for the truth of the matter asserted. And the post should not come in. I don't know who posted it. It would have to lay a foundation for the writing.
So the fact that the posts were made and that they were publicly made is part of, is the evidence itself, not that it's true. This death to the big homie sent the word
What-
out from behind the wall.
What would you have the answer generally be? I mean, what would you presume his answer would be, or your question and his answer?
Were there threats made against YSL in the moments, hours, days following Donovan Thomas's murder? Yes, there were public threats, social media posts, and the like, and these would be them.
Okay, well, that would. Okay, and that would be overruled because it isn't being offered for its truth. Okay, but we can just do that at the point in trial. We don't have to have this slide.
Okay.
So the slides out.
Slides out. All right, slide 10.
L after L for Love's redacted presentation.
Tell me, I guess, what I'm looking at and why he's going to be using this.
We can take this out. I think that this picture is already in any event.
What'd they get in the picture
Right.
of the gang house? The gang house, the gambling
Slide
house?
11. There's a lot going on this slide.
There he is. He can testify about that. It's basically it's Mr. It's the services of the victim in this case. So he can testify about it.
It's a good
Take the
question.
victim impact.
What would be the
Just-
relevance of how, many people were moved by his death?
So she laughs.
Judge, if I may come back to the court on that, I can take out the slide and
Okay,
as to the questions about it.
all right.
So 11's out.
So the slide, yes, 11 is not
Adams.
going to be used, and
The
she'll get back to me on the relevance of how crowded his funeral was.
he's very loved.
She just mumble he's
And
very
maybe it
loved.
is. I don't know. But
Why is that relevant for
All
the
right,
jury to hear?
slide
That's so
12.
that's like a victim impact for sentencing, not for
So
guilt.
how about slide 12?
We can take out that. It's a similar one as the one earlier, so we can take out, we can take that out in the same way and introduce it if we need to. And
Okay. Thank you.
Yeah, that was wild. She just hot mic'd he was loved. She should
Is
know
the
better.
picture with the placards from obviously some shooting already in evidence?
I don't think this particular one is, but it will be. We anticipate that this will be
Okay.
admitted in
Well,
evidence.
if you want to present it to him and ask him about it, that's fine.
Okay.
And the second one on there, do y'all intend to have him talk about that picture?
We can take that out.
Okay.
L after L.
All right. So then
Moses, I think she's
13
piecing it
essentially
together
won't be
that-
used, and you can, if he can identify what's the crime scene photo, then he can testify to that.
That
Okay,
love just wants to do what love wants to
Number
do.
14.
You guys were not kidding about this PowerPoint.
So, Judge, we don't
Arguments
have
being wild.
Number 14, we would need to introduce, I think, the photographs versus putting it up.
Okay.
We would, yeah, as opposed to using it as a demonstrative.
Okay.
There's
And
some
I mean, if they're
photographs.
already in, then obviously if he needs to testify to them, he can. And if they're not in, you need to be able to, obviously you need to be able to lay the foundation.
Right.
but-
And we may just get, some of the ones that are, as the court has already pointed out, some of the ones that are already in and put them on, just to use those as our exhibits with
Okay.
him.
She's got like one slide and one photo that can be used new out of all of this. Thank you, Moses. Like, this is crazy.
I mean, presumably this shows everybody's
Whitaker chose violence today.
in relation to these three people.
It does. He testified about that. But this is just like putting faces to the names and sort of family diagramming. And I think we actually did that earlier. So it would be referring back to something that's already.
I'd be objecting. Your Honor, the mother, if I interrupt, I apologize. If the mother of Mr. Thomas testified to family relations, the father of Mr. Thomas testified to family relations, and Detective Dennis testified. Now, he may not have, actually. He may not have. So it's definitely the parents, the mother and the father, I would be, it's just repetitive.
Okay, sounds like she doesn't intend to use this anyway, upon further reflection. All right, slide 16. We still have a current intent to use this slide.
We cannot use 16.
Okay. Okay, 17.
17. We can as well not use, so I think that what we'll do is just take some of the pictures, photographs that we've already admitted
Okay.
and use
Just
those as
giving up?
exhibits rather than trying
Okay.
to introduce whole hog. this
Sounds
PowerPoint.
reasonable.
Whole hog, because she didn't want to
So
say wholesale.
18, y'all still want to be using that?
No, we cannot,
Okay.
we cannot.
Jeez, look at
Well,
Whitaker.
except that I think that the photograph in the bottom right corner
Yeah.
were guns that were recovered. But I'll confirm with Dennis. I won't need so that might be something that we could use as an exhibit and not
Okay.
a slide. So if there's anything in this picture, certainly not the top three,
Okay.
but if that bottom right picture, if we do anything, we would tender it as an exhibit versus trying to put it in on a demonstrative slide.
Okay, and these are all
It was the stuff that was collected from
from
one of the vehicles.
an alleged rival gang?
Yes, after the shooting at 1006 Hill Street. Actually, not the rival gang. This was the one that was collected from the people who were shooting back at the people who were shooting
Oh,
at
okay,
them.
all right, well, I mean,
But
I could anticipate some potential objections from the defense at the point in time if you seek to tender that, but we'll just deal with that at trial. But don't be surprised, because I certainly think if I were the defense attorney, I might have an objection to it.
I think they wanted this part in because this
Oh,
is from
well,
the
we'll
other
see.
side. This is
We'll
the
see what
guns
the
from
strategy is.
from the other side. This is-
We'll see.
okay.
Okay. That's what makes trials interesting.
So 18 is out.
18 is out. 19.
Adams with the double checking is great.
19, we have not yet introduced that photograph, but I think that we've,
The one on the bottom or?
yes,
okay.
the one on the bottom. Part of that photograph is part of what was talked about in the interview with Mr. Copeland that has been shown to the jury so far. So we could definitely take out the word, we'll do whatever the court instructs, but that photograph, we can introduce it as an exhibit if it has not already been admitted, and we cannot publish the PowerPoint slide.
Okay.
And in that vein, Judge, with respect to, since we're going through it like that, rather than introducing, no, I think maybe we should, I was gonna say, rather than introducing the whole thing as just, here's his demonstrator that he's using, since we're cutting it up and using parts of it, rather than saying, okay, we're gonna use this, we won't use the PowerPoint.
Right.
We'll use exhibits that either have been admitted or
Okay.
that we tender through
Okay.
him.
All right. And so that'll be true for the rest of us?
Yes.
Okay.
So the whole PowerPoint's out.
Well,
Am I hearing that correctly?
we won't use the PowerPoint.
Yes, that she's just saying it's going to be easier not to. Because I mean, I would imagine he's probably kind of like press play and he's like, here's what happens in slide 1 and slide 2. And if he's not doing that, then it might be easier to do it another way.
Right.
Okay. All right. So then I guess as for the rest of it, we can keep going through with regard to the pictures themselves, or you can just, if there are some pictures depicted within the slides that the defense thinks are particularly egregious or objectionable that you want to go ahead and alert me to, that's fine. Otherwise, I guess we'll just see what happens at trial.
Your Honor?
Yeah.
Wouldn't the same rule that your court said the state now will give us what they believe they're going to introduce as an exhibit through Detective Dennis, and we could raise it with you?
Yeah, that would be helpful. I mean, you're going to want to take a look at this and then decide what you actually want to use. So once you kind of narrow that down, if you'll just let the defense know which ones you actually want to use, then they can raise any kind of objections that we could get taken care of outside of the presence of the jury beforehand. That's fine.
So
Thank you.
Can I just make an observation
Sure.
or an objection? So before this honorable court took over, there were lots of objections as to, it was Detective Dennis allowing to say his investigation. So not a witness came in, the crime lab person didn't come in, just he was allowed to say, I learned of, and these CAD reports, I objected to everything on confrontation clause and hearsay. And the former judge denied it. So it all came in. I think the state, is about to do the same thing with the same witness. And I will be objecting again. And I also have this section. I'm looking for Georgia cases.
Okay.
It says, this is, I have a couple cases. This is United States versus Wynn, Nguyen, that's wrong. 504 F3rd 561, 5th Circuit, 2007. Thus, while summary witnesses, which is what I call Detective Dennis, may be appropriate in complex cases in certain circumstances, they are improper for introducing evidence that the jury has not previously heard. We repeat our admonition that the government may not use summary witnesses for inappropriate means. While such witnesses may be appropriate for summarizing voluminous records, as contemplated by Rule 1006, rebuttal testimony by an advocate summarizing and organizing the case for the jury constitutes a very different phenomenon, not justified by the federal rules of evidence or our precedent. So to me, this is what I call a summation or a closing argument. And I know that the court struck it, so I don't have the same exact situation as my motion to exclude this, but this whole thing is a closing argument. This is PowerPoint was a closing argument. I understand it's no longer like that. It's dismantled and now we're going exhibit by exhibit and rulings. But my point to the court is if you can just, I might ask for an advisory opinion, but this is going to be, there are 2 Detective Belknap, 1 Detective Gaither, maybe 2, but 1 Detective Gaither, I remember, 1 Detective Dennis. They've all been over objection, qualified as experts. They're on the exact same situation. And now we're going to replow. Detective Dennis already testified as to the alleged back and forth. He already said all this.
Okay.
So did Detective Gaither. It's all over objection, but I would object that it comes in now again.
All right. And what would be, what's he going to be talking about new? Why are y'all presenting him again?
So because he's sitting through some of these, specifically some of the interviews that we were
Okay.
talking about some of the actual shootings that we're showing the evidence of, like on April the 28th, the Hill Street shooting, he touched on them. We did not get into, like, he as an expert talked about what their investigation led them to do and sort of what their investigation entailed. He didn't talk about the details. We won't be getting into rehashing something he's already talked about. The stuff that he's going to deal with now is going to deal with specifically the interviews that he conducted, depending on what the witnesses say. If there are some instances where, you know, we don't need to play the interview because they say exactly what they said, then we won't do that. But we're at a different part. He is a fact witness, and he's still he has still been qualified as an expert by the court. So we won't be rehashing stuff that he's done, and we won't be using, I'm not certain what Mr. Steele says, you know, he objects to summaries as experts.
But that's confusing the flip-flop.
About how they arrive at certain conclusions.
Yeah, I
Because
think
you have to
there were maybe
instruct.
like a couple of different objections in there, but it sounds like one of the objections or potential objections would be if he's going to get up and basically rehash the same thing he already testified to about how, you know, the theory is that all of this came about because it was the culmination of, you know, some gang wars, basically.
We've already
That's already been covered, so he should not be testifying to that again.
Right, we don't need to, but specific, like the April 28th shooting, the Hills, like we haven't put up all the evidence in some of
Okay.
them.
Nobody in here is being charged with that shooting, right? That's part of the story of some of the crimes that are charged in the indictment, right?
I think the court is saying that they are overacts. Some of them are overacts that are listed in the indictment. If that's what the court is saying, the answer is yes.
Okay, so I may be thinking of the Hill Street shooting as something other than what it really
The
is.
Hill Street is not, the Hill Street is not.
Right, that's when Woody and his girlfriend get shot at, right? Or no? Okay, all right, sorry, there are a lot of shootings that I haven't been in this case the whole time, so. All right, so, but I guess, so let's take, for example, that one. I mean, we're not gonna need to get into the nitty gritty of that one, because that one, all that we need, all for the jury to know for that is it happened, some people believed it was a rival gang, it, you know, made the beef worse. We don't need all the details about how many bullets were found, right?
That was free to read. That was Lucci's mom.
Oh,
And so
Well, that
he's-
was another one, but
so the overacts connect that shooting with the ballistics from that
okay.
shooting.
Okay, so for that reason, that might be relevant. but-
And Lucci's a central sort of
Right.
opposition figure
Okay,
in the whole.
well, I guess I'll just have to take them as they come, but we do not need a whole entire like crime lab. Here is, you know, what you would put in if you were the state prosecuting that shooting, when that is not an overt act and it is just something that happened along the way that's part of the story. I don't want us to be having a mini trial about that.
And we've scaled back everything
Okay.
in the indictment, even like we were saying yesterday with the Rodelius Ryan murder.
Okay.
We've scaled everything down
Okay.
like that, so
All right.
it's not to.
So are there other objections encompassed within what you just said, Mr.
Right.
Steele, that I need to be addressing?
I don't see why Detective Dennis, through his investigation, is allowed to say, oh, there was a Hill Street shooting and this was gang related, or this was done by this gang in retaliation of this. And we linked up later through the GBI crime lab.
Right, is this, how
that
is he a
was used in
fact
this
witness if
shooting and
that's
another
expert
shooting. You know,
testimony?
to me, that's all confrontation clause. And the investigation doesn't matter. They could have done the greatest investigation. What matters is that the state put up competent evidence before this jury to determine the charges and the elements of the indictment. So to me, it doesn't matter what their investigation was. Now, I have challenged the investigation that they did not verify or corroborate. I have no problem with that, saying, well, I did verify and bringing in the witness, or who the witness was that they spoke with. Maybe not what they said, but what happened last time with the predecessor judge was over objection. Detective Dennis and Detective Gaither was able to say, oh, we verified that this happened in relation to this, and this happened because of this, and this started a chain with this. And this whole thing started in the fall. By September 2014, there was no witnesses here.
Okay, well, I mean, that's the subject for cross-examination then.
It's hard to cross when I have no reports. I have no reports. I have no expert report. I don't know who to interview to say, no, that's not true. I never told them that. In fact, I told them something different. This is all to me like I have a bag over my head and I'm getting smashed with a baseball bat and I have no idea where to hit because I don't have anything. And I've asked for reports. Judge Glanville told the state to produce it to writing. This is all confrontation clause and it's all coming in as a conduit through some quote expert. And it comes through with many experts. And to me, it's just like not having a trial.
Okay, well, I'm sure you'll be able to undertake an effective cross-examination of this and every other expert witness. I have been told since I've been in the case in front of.
They
y'all
said they
in
wanted him
court
to be a
that there
fact
aren't
witness for
expert
this.
reports. Does that continue? And y'all were going to circle back and ask whomever over at APD to do an exhaustive search, even if people were retired. What happened from that? Has that been
For
conducted?
police reports, yes, we were, actually, I think the court told us to do it for a specific act, and I can't recall which one it was, and we did, and there wasn't. But we have done that. We have provided the police reports for these acts that are shown, that we're showing evidence for, and that we are asserting in the indictment.
All right.
So
Okay, you recall that I did tell y'all to go back once again and say, we don't care if people are retired. We really need you to find this and make sure there's no reports in it, right?
Yes.
Y'all did that?
yes,
And
you
that produced
did.
nothing?
No, we
Okay.
nothing that we haven't turned over, because
right.
what we did, what the court required us to do was, it was for a specific one.
I don't think it was.
Hold,
I mean, it may have been for a specific one and then everything else. But anyway, if it wasn't done for everything else, do it for everything else right now.
Your Honor, could we take a very brief restroom recess?
We just had one less than an hour ago. So, no.
I'm sorry. Okay, I apologize. Mr. Adkins is reminding me that you're talking about gang expert reports and things like that.
Yeah.
And yes, we don't have anything extra. We will go back again, because I've gone over and asked homicide. I've asked gang. I've physically gone over to the gang unit, physically pull out boxes of stuff. I will continue to inquire.
All right. Well, I don't know that, the best use of your time is to pull in boxes and look through them. That ought to be what the police are doing, but you need to direct them to do that.
Yeah.
And so with regard to the gang experts, did y'all go back and say to somebody over at APD in gangs, hey, we need anything there is, even if these detectives are now retired?
Well, we had done that before the court ordered us to.
I know, but then I ordered you to, so did you do it again?
Okay, so
Because I ordered you to.
we have not inquired a second time, and I apologize to the court. We're gonna do it again. I will do it.
I pretty
personally.
clearly told you to do it again.
That's what he's reminding me.
Yeah, well,
So-
Mr. Adkins, you could have done it.
Yes, Your Honor. I'll go make a phone call now.
Okay.
And can I mention something? It came out during trial, during a motions hearing, that there is what I'm going to call a black book. And it's all the gang information.
Yeah.
Okay, you seem like you know about it.
I've
Well,
heard about this before.
Okay, well, I don't know about it. And we were told, we were given the Heisman. We were told that we're not getting that. Detective Dennis said he no longer works at APD, so he has no access. Detective Gaither said the same. Detective Belknap,
Look at
who
Yak.
continues work there, says that's not for public information.
Well, I would imagine it is not. However, if such a thing exists, do y'all know what Mr. Steele's referencing?
If he's talking about what Detective Dennis said that he used in the beginning of his career as a law enforcement officer, where he collected information, I think maybe he called that maybe a black book. I don't know if he's talking about that or if he's talking about the information that they keep on gang members. I'll let him clarify, but.
All right. Do you know, Mr. Steele?
I'll take anything that has to do in any way with the testimony in this trial, to either be able to go and interview the witnesses, confirm the witnesses. There was a lot of talk over objection. The policy of APD, how they qualify somebody as a gang member, it's self-admission, it's somebody else who's reliable, which say that they're in a gang,
Okay.
they hang out with somebody, all that's in this supposed book. I don't.
Okay, that's entirely different.
Okay,
because-
so you now do know what he's talking about.
No, that's entirely different. Detective Dennis talked about, and Detective Belknap talked
Mhm.
about how they identify gang members
Okay.
and what criteria they use.
All
It
right,
is
is
not
that
true
something that is in
something in a
writing?
black book.
Well, whatever. Is it something in writing?
I think that the criteria,
Okay.
those criteria that they use, that is something that is a written sort of criteria,
Okay.
and I'll
All
get
right,
that.
let me propose, if that's easy to get and they don't have kind of security concerns with it being provided to the defense, then provided, if they do have security concerns, then it can be satisfied by saying, Mr. Steele and anybody else on the defense team, you can come look at this written policy, at 12 p.m. on XYZ day over at APD. That satisfies it also. So in some way or another, if there is a written something that is how they classify, then give them access to it in one of those ways, okay?
I will, and we will also check to make sure that we've not already given them standard operating procedures as it relates to
Okay.
gang unit.
Well,
and gang
obviously, if they've got
identification.
it already, then they've got it.
But in terms of being able to cross-examine the witnesses on specific incidents that they've discussed, we've turned over entire files relating to each of these incidents.
Okay. All right. It sounds like what Mr. Steele's talking about is the sort of policy that you just mentioned, that are the guidelines, the criteria.
I actually want the specifics of who they spoke with. They're talking about,
All right. Well, they may or may not have anything like that in writing.
Well,
And you can always just interview the detectives
well,
to ask them those things.
I have interviewed the
Okay.
detectives, and they tell me that they're not releasing that information. They would speak with somebody. They'd speak with Brian Steele. Brian Steele would say that Keith Adams is not involved in criminal street gang activity. That would go into some sort of book. Then they would speak with Carlton Matthews, and he would say that Brian Steele is in a criminal street, and that would go in some sort of book. I'd like to see that because they're speaking about, we corroborated this. So I asked on cross, who did you speak with? I'm not going to tell you. Well, why don't I have the right to know?
I don't know. Maybe they consider them confidential informants.
He never said,
have to
I'm
get-
not, I don't think he ever said, I'm not going to tell you, Judge. I think
All
that
right,
what.
I'm not going to relitigate it. If it comes up again, we'll deal with it then. Okay. So I'm not even sure how we got on that. Oh, but Mr. Steele, you've said a couple of different times that you object to certain portions of CAD reports as being hearsay, and you were going to give me some law about that. And I don't know if other CAD reports are going to come in or not, but. Okay, well, provide it, and that way I'll provide it to the state as well, because if it's clear law, then they can just redact those portions of CAD reports which might need to come out as hearsay. Okay,
So I have KAMUSOKO versus state.
yes, I'm sorry, start over. I just didn't get that at all. KA,
KAMUSOKO
okay,
versus state 362 Georgia Appeal, 276 footnote 3,
and what does it say?
868 Southeast 252 2022. Says Camusoko makes no distinction between any particular statements and declarations, and therefore has abandoned any challenges he may have regarding particular statements or declarations. There is nothing for this court to review where the appellant has failed to identify precisely what statements he challenged. In addition, although Camusoko mentions in passing that whatever was said to the 911 operators was filtered through people who did not testify at trial, he fails to include either citation to authority or meaningful legal argument that the CAD reports were inadmissible because the 911 operators or other persons writing down the declarant statements did not testify at trial. He therefore has abandoned appellate review of any challenge to the CAD report on this ground as well, and that ground is hearsay and confrontation clause. It's in Division 2 of that opinion, but I read
Okay.
from footnote 3.
All right, so, I mean, that doesn't establish that if objected to, it would have been an objection with merit. It's just saying, hey, you're raising it on appeal, you didn't raise it below, we're not going to deal with it.
But it's not, right, but the CAD
So,
report
okay,
could be
maybe you could come up with one that instead of saying this is a potential issue, says, all right, here's the issue, and in addressing it, here's the law on that. Can you try to do that? Thank you. All right. Okay,
in this case, in Division 2A,
all right,
where the footnote 3 is,
okay,
and what the court said was it's admissible under an excited utterance of hearsay. It's
Yeah.
hearsay with an exception.
right,
So
okay.
my point is, some CAD reports they don't identify an emergency situation. So they're identifying a past event. So that would be a confrontation.
Okay, well then, you'll just,
It depends
if you
on the
plan
CAD.
to make that objection to every CAD report, then give me the CAD reports
Right.
and I will make a ruling.
That's right.
All right, let's do that. So that can be on the agenda for tomorrow. Okay, thank you for clarifying that. I do realize that there might be times, I just thought y'all had some kind of blanket, this part of the CAD report is always out. And that is not what we have.
Right, it's like a
Okay.
911 call. It just
Yeah, no,
depends.
I'm clear now with what you're saying. All right, so we've done the PowerPoint. So I am going to give us another quick break, but I'm going to say, and I'm going to say this once, and I don't want to have to say it again. And this is kind of what you say to little kids when you're on a road trip with them, is if we're taking a bathroom break, even if you don't have to go right then, if you could hold it for
Oh
another
my
30 minutes,
goodness, we're getting
just take the
instructions on peeing.
opportunity to use the restroom so that we don't then 30 minutes into court again, have to take a break because now you can't hold it anymore. Okay? All right. So we'll have a little recess.
Yeah, we're gonna say it. I was gonna try to say something. FFS. Adkins on the roof. I was gonna try to say, I hope he doesn't consider anything crazy, because we want him to come back down. Then the chat did the assist. They had a bunch of other theories. Adkins is on a pee break, potty break. And I don't know, is it Adkins with the T or Adkins with the D? But yeah, the idea of someone being on a roof, still very serious. Even though we're lighthearted in this chat, we don't want to make a joke out of that. Although, you know, where was the one about the cigarettes in the car bumping Thug? I'll say that's maybe a strong possibility. You may have seen me say in the chat, I actually think it was nice that Adkins just got up and took action instead of arguing for the next 30 minutes to give an excuse to Judge Whitaker why something that was supposed to be done wasn't done. Like, we might say, hey, he sits there, he doesn't really lead much of the questioning, but instead of pulling a love and trying to excuse actions, he got up out of there, went to make a phone call. So shout out to him for that, for real. THX, thanks for becoming a member. Moses, thank you for starting the all caps vent session. That's always a good time. The chat always has a good time letting it out. Miss Kims, so good afternoon to you, Miss Kims. Anything exciting missed today? If you guys are tuning in a little bit late, we are still catching up with the day, but really that PowerPoint got slammed down. They tried to go through about 18 slides of it. There was one slide with a single picture of the gambling house. There's no pictures and evidence so far of the gambling house. So Whitaker's like, yeah, that can come in. Pretty much everything else. Do we already have that picture in? Okay, well, why do you need to introduce that now? Or why would you try to even introduce text like that? Nope, that's out, that's out, that's out. So really, really crumbling on this Operation Planters PowerPoint thing. So some other stuff earlier, they went over some statements, Bruton issues with Yak's statements. I think Steele, anytime something wasn't a very important argument, he's like, this might not be Bruton. But there were some other things that were excluded, with Bruton being the reason why. It was a inculpatory statement by a co-defendant against another co-defendant. So pretty good stuff. And then earlier, I have to get the timestamp now because we've been going for a while. Boy, there was one funny part where the judge had Hylton tried to keep making an argument after she made a ruling, and she's like, I've already made my ruling. That's enough. That was pretty good too. Other than that, we're still rolling. We're catching up. Sheenie Beanie says, having to go back a second time for those police reports was Adkins' 13th reason. No. And then FFS is saying, is Adkins is calling Steele's law firm. Like, are you guys hiring? And there we go. So instead of unaliving, just pondering life. Why am I here? Should I reconsider my career choice or my employer choice? That is reasonable. That is definitely reasonable. And then Ms. Kim, thanks so much for the $19.99 super chat. Yeah, we are not, you didn't really miss that much because you can see on this progress bar down here, we are also catching up here. We are on 1.25 speed. And hopefully anyone in the chat that needed to pee took care of that because we're going to skip the rest of this recess. There you go. Thanks so much, Ms. Kims. And yeah, I was using the break to get caught up. That way I didn't talk over a good argument.
I think we can move on to another task on our task list. Open to suggestions, or I'll pick one. I know we still have to do the excerpts from the wiretap evidence, so that might be a good thing to turn to next. Yeah.
I meant to bring this up yesterday. We've been labeling the excerpts from the wiretap as potentially co-conspirator statements.
Right.
And I think the state announced that those wouldn't be coming in until Investigator Viverito testified. What I meant to inquire about the other day was, I know that they've suggested that there are additional co-conspirator statements. I'm just wondering if any of those are linked with witnesses coming up soon.
Hang on just a second. Nobody say anything because our court reporter needs to plug in back up.
Dang, tons of issues with the tech today. Yeah, it is nice to be able to fast forward through some of the breaks, and it would have been great on Friday when they were having all those tech issues if we could, because if we condense that down, I feel like a third of the day was pauses for tech issues. It would have been a third less of stuff we had to sit through that wasn't actually happenings in the trial. There is a day right after Labor Day where I have a whole day booked of stuff to do. We could do an afternoon and eat, well, my time zone. You're in Australia, what, why, and who's. But we can do a crunch session, skip all the recesses. For me, it'll be like a happy hour stream without the drinking. And the ability to do the 1.25. And it's funny because there's occasionally still some buffer emojis when someone's speaking a little bit slowly or losing their train of thought. But it's still pretty helpful.
Rebooting, so I thought you might have something that was not something we needed to take down.
And that's great, Joey. She was giving them event session.
Some research to do on our case tomorrow. So with Mr. Williams' permission and Ms. Adams' permission and the court's permission, I was going to do that at my office. And I will not be here tomorrow if that's okay with the court. And Mr. Williams said that's okay with him. He could speak for himself, and Ms. Adams said that's okay with him.
All right, sounds good. Thank you. Okay, we're back up now. So I don't know if all of what Mr. Sharp said got on the record. Do you mind just reiterating it?
So, yes, I will. We put off, we suggested that the wiretap co-conspirator statements are going to come in through Investigator Viverito, which would be later on in the trial. But I believe that the state has also stated that there are additional co-conspirator statements or alleged co-conspirator statements that are not part of the wiretap. And I was just suggesting if those involve witnesses that are coming up sooner, that might be something that we need to address.
Okay. Do we have other co-conspirator statements that are not the ones from the wiretaps coming in through to Investigator Viverito?
So, since we won't be getting to the wiretaps until she's number 91, witness 91, in terms of, okay. My question to the court is, would the court allow us to go in order of the witnesses that are coming up and deal with the buckets of exhibits?
Yeah, that's fine. And I think that's kind of what the defense might be trying to figure out is, do we have some co-conspirator statements that are going to be coming up soon? And I'm fine if it's easier to just say, okay, we're talking about co-conspirator statements now and tackle the ones that are coming up soon. That's great. Or if we want to go witness by witness through, here's the evidence that's going to come in with this witness. I think either way makes sense, but let's do one or the other.
Thank you,
So,
Terry,
yes,
for
it
reminding
sounds
people
like
about
maybe
the
there are
like
some other
button.
co-conspirators or alleged co-conspirator statements that are going to come in soon.
Not any that are coming up soon, not soon.
Not soon.
The witness buckets would be the most. The next, Jamari Holmes is the next time that we'll have co-conspirators.
Can y'all all hear her?
I'm sorry, I'll get closer to the mic.
Okay.
Jamari Holmes's murder is the next time that we'll have that issue. And that's the one that we were discussing at the beginning of court with Your Honor and
Okay.
Mr. Williams and Ms. Abbasi.
Okay.
So the co-conspirator,
That's a little ways away.
yes.
Does that answer your question?
I'm fine with that answer. As long as nothing sprung on us at the last second with these witnesses coming up, I'm fine with that answer.
Okay, so they do have what those co-conspirator statements are, right? We don't need to litigate it right now.
I'm sorry, I missed what the court.
Do they have whatever the co-conspirator statements are, whether they're from the wiretap or a different source? Do they have them all?
Yes.
And have they been identified as potential co-conspirator statements?
Yes, Your
Okay.
Honor, for the most part. Just 1 second, I'm going to confirm one thing.
Okay.
Get it together, Adkins. Adkins coming with the play call. Thank you so much again, Terry. I don't know, personally, I love the reminders to like the like button. Ever since they changed this interface last month, there's been times where I'm in other chats, and because I see someone remind about the like button, I'm like, oh crap, I didn't do it, and I'm usually really good about it. Because now you have to like minimize things, find the like button, pull it back up, and it's all glitchy. But I appreciate you guys making sure You hit that like button. It's free 99. Right, it's easy to hit the like button because everything pops up with it kind of covered now, the new interface. Yeah, we gotta like the smash button. Yeah, you heard the bucket term again? I didn't know that was a term. I thought she made that up. Is it a term or am I just adopting vocabulary that's not really vocabulary?
Sprinkles folder,
Bucket equals one video to
um,
love.
have potential co-conspirator statements in them. We don't have them extracted out. We just have the ones in there
Okay.
that we intend to use.
All right, I mean, y'all ought to be aware that if there are jail calls by co-defendants, that those might contain co-conspirator statements. So that would be the only thing that might not be specifically identified as that. Okay.
My expectations are correct in line with the courts. The state is going to specifically identify those alleged co-conspirator statements. Correct. I mean, there's thousands of jail calls from probably, I'm underestimating, well, thousands, yes. So we would need to know what statements, when they're made, between whom and whom, if the state, because we would like to litigate these beforehand. I know the court would too.
We put in the Mike Sprinkle bucket, the jail calls that we're using.
All right, so jail calls y'all intend to use are all in the Mike Sprinkle folder?
The ones that we, yes, the ones that we have identified that we intend to use, and those are the ones the court told us to.
Okay, so the universe has been narrowed, hopefully substantially. I haven't looked to see how big the Mike Sprinkle folder is, but
If it's the same one that I think they're talking about, it's about 200 calls,
okay, well. then-
15 minutes each. So that's 50 hours of,
Okay, which I presume is one of the reasons y'all said, let's hold off on dealing with what's in the Mike Sprinkle folders. So as the state, look here, as the state is itself going through the Mike Sprinkle bucket in further detail and identifies for itself the specific co-conspirator statements that it intends to introduce, please identify those as well to the defense. As soon as you know, let them know.
So we have 14 in the Shannon Stillwell folder. We could start there since that is his client, Mr. Shart's client, that we could actually review.
Okay. Let me get some clarity. So in the Stillwell file of jail calls, are those already identified? Just here are the co-conspirator statements, or are they just like, here's a 15-minute call, here's a 5-minute call? All right, and do you know what portions of those calls yeah. All right, but whether you've broken them out or not, do you know what those are?
Yes, that's why we put those 14 in there.
Okay, so if you can, if that's what I'm saying, is once you know, here's call from January 2nd, that is 15 minutes. I'm going to use minute 2.5 to 2.9. That's the part I care about. When you know that, let the defense know that. Okay, so if you know that already, instead of us sorting it out here live, give that, one of y'all sit there and type it up and send it over. They can look at it tonight and we can deal with it tomorrow. Okay. And similarly, do that for everything else. All right. So that it sounds like the most productive thing to move to next, unless somebody else has a different idea, I'm willing to listen, is to just open back up, you know, the witness folders and move on to whomever the next witness other than Mike Sprinkle is going to be. And go
Whitaker
through
paused
that
before saying
proposed
folder
evidence
instead of
for any
bucket.
kind of evidentiary issues we can hash out now. All right, let's do that.
They can't stop. Look at them.
Why do I hear something?
Oh my gosh.
Dropbox link we were working from yesterday. That is the Dropbox link of the first 30 witnesses. So if everybody can find that again. Bless
Wait, I barely heard the sneeze, but I heard the bless you.
It's not easy to find it because sometimes instead of y'all giving each a new reline to your email, you just tag on to one that already existed.
Hey, Atkins is like stuck in the middle of this all day. It's been going. I really want to revisit that theory of like why he was so willing to run out there and make that call to get things moving. Right, definitely in between them for a
2024
reason.
email from Mr. Adkins.
I'm pretty sure. That's right, right?
Yes, Your Honor. It says 30 witnesses, and then it has 8 August 24 in parentheses.
That could be true. I kind of saw it as a, okay, whatever, I'm done. Like when you kind of like start to lose your patience with someone and you just
All right,
smile
well, let
and
me know
like
whenever
Whitaker
everybody's
giggles
there.
it off. But that could be true too, that Hylton's smiling, maybe they aren't arguing. You guys think about earlier when Love made the comment that she was down at APD pulling out boxes, looking through papers in relation to this sentiment, this pretty big consensus that she doesn't get her homework done. Was she just trying to paint visuals of her doing work when she said, oh, I
Is
was doing
everybody there
boxes at
now?
APD, which is not something I
Almost.
should have to do.
All right.
Yeah, and Kayla did say that they argue like this frequently. Miss Kim says Atkins has his finger in his ear when Love talks. Oh my gosh, can you imagine going to get like a hearing exam done and they tell you that you're losing your hearing a little bit in one ear and it's the ear that's facing the person always leaning in to argue over you to the person sitting on the other side. And we love Drea. Drea has a lot of work to get done today, so she's not here tuning into this afternoon live stream. But she's okay. She said she had a lot of work to do. But it's so sweet that you guys notice.
I'm waiting on y'all to tell me if you're there. All right, is everybody there? Has everybody got the 1 through 30 Dropbox link up?
We have the full, Kendrick has the folder.
Okay,
I don't know about you.
great, thank you. All right, I've heard from 2 of 6. Y'all ready? Okay, 3. Stay ready. Okay. Mr. Matthews, you got it? All right, who else? Are you ready, Mr. Sharp? Okay, Mr. Adams or Mr. Steele? Okay. All right, here's the one we're waiting on. Okay. We'll catch you, okay. All right, I think that we yesterday had gotten, other than Mr. Sprinkle, through, there was nothing with regard to any of the phone custodians, right? Sure.
And I try to skip these pauses, but I can't really tell when they'll start saying something, so I don't want to like skip by something interesting. Look at them arguing though. Let's watch them argue on 2 times while we catch up.
Sure. All right, so the question on the floor was whether there's anything we need to look at with regard to any of those three cell company custodians.
Your Honor, if they would like to stipulate, we can, as to those records, we can just bring in the records themselves and save that time, but.
That would be nice. How about it? Miss Westmoreland doesn't want to. Okay, no, that's not gonna happen. All right, well, so we'll have three more witnesses, but with regard to the evidence within those, any kind of motion and limine type issues we need to deal with on those? Thank you. Okay, then James Burney is the next witness listed.
We'll talk about that cell
Do we need
location
to
stuff.
look at anything with him?
Expert from the FBI phone records.
Okay,
And this is one that I voiced an objection to repeating the testimony because Agent Racy talked about for a long time where the phones were located. The prosecution stated that based upon questions by some of the lawyers for the accused, that they needed to do something else. I'm still holding my objection because I believe it's going to be, I looked at the report, it's the same thing, maybe a little nicer because it was done nicer. And I don't mean to insult Detective Racy. He didn't have like a, a chart, but I just believe that it's the same. And by when the same, I'm talking about the April 26, 2015 shooting of the tour bus of Mr. Carter, a performer known as Lil Wayne. Otherwise, no, I don't have any issues with with
Okay.
Agent Byrne.
all right.
And Your Honor, per the court's guidance, this April 26, 2015, we are not discussing the Special Agent Burney. This, when he speaks on specifically the January 10, 2015 murder of Donovan Thomas, that's the only cell records he's going to be testifying to right now. He does analyzes cell site tower data for other acts in this case and counts. So he's one of those witnesses that testifies multiple times when that act comes up. So what Mr. Steele, specifically the April 26, 2015, we will not be
Calling him for that purpose?
correct, Your Honor.
Okay, but so when he's called here, it'll just be for the January 10th,
2015. yes, Your Honor.
2015?
He
Okay.
sat down
Anybody
right
else?
now.
Nope, I hear, all right, not hearing, but I'm seeing nods, no. Okay, all right, great, we'll move on to the next.
Thank you,
witness
FFS.
Folder.
Christian
All right,
Adkins with a
GBI
D,
firearms
not a
boss
T.
In Wheatsell or Whitesell. Any issues on those?
My understanding is that these witnesses listed are the witnesses that are going to be called. Is that correct?
Mr. Voss is not going to be called pursuant to information we sent to you all a few weeks, 2 weeks ago, maybe. Mr. Whitesell is going to be called. I believe there's, on the email that we sent to the court and to counsel for the defense, the peer reviewer and the verifier for David Voss would be called rather than Mr. Voss.
All right, and is that peer reviewer / verifier Whitesell?
No, it's actually Vanna Kelly.
Vanna Kelly? Okay.
Yes.
Is that Ms. Kelly?
Yes.
Okay. Does she have her own reports?
No. Actually, what we're doing is getting the data, the underlying data. So she verified these. And so any underlying data that she has that they may want, just in case they want it, we have to get that for them.
Okay.
It's unclear to me the work that I guess Miss Kelly did on this case. It's unclear to me what the work she did was, but obviously, Your Honor, there's potential for confrontation clause issues involving Miss Kelly testifying to the results.
All right. I would presume, I mean, typically when they testify, they say, I ran all the tests myself.
Right.
And obviously if they didn't, then that's going to be problematic.
Right, it would be. She looked at the evidence under the microscope herself and came to the same
All right. So
conclusion.
she will be testifying to her own conclusions, not to his
Not-
conclusions.
Right, hers match his, and he was the one that put out the report. She verified his by going through and running looking at that physical evidence under the microscope.
Okay, but her conclusions will be based upon her own
Correct.
testing and observations.
And to my understanding, we don't have a report from Ms. Kelly. If she, maybe she's not writing a report, I don't know, but I'm bringing it to the court's attention, the state's attention, that my understanding is we don't have a report from Ms. Kelly. So if one was generated, we need that report.
That's what I was just saying. She did not generate a report, but her underlying notes and data, that is what we said we would get for them because her conclusions.
She doesn't have a separate report, but she's got notes and data, and y'all will be provided that when? Y'all have that yet from her?
No, I spoke with the GBI last week and I'll follow up this week.
Okay. Let them know that this is an ongoing trial and they need to
I will.
provide it ASAP and then provide that over ASAP to the defense. Okay.
Also, with respect to Agent Bernie, if we could swing back to that.
Sure.
He will likely not be testifying until the end of September, in which case any time needed, we believe, for the defense to review his analysis of the April 26th incident would have, we believe that rather than having him testify 2 different dates for those, for the incident here and the incident in April, would be obviated by the fact that he's going to not be testifying until the end of September, as opposed to having him testify at the end of September and then come back 2 weeks into October. So I guess we're asking for clarification on whether or not he can just be brought in, whether that is not enough time for them to look at the additional reports that they were given last week, or was it last week? Week before? Week before last, right.
Okay, let's find out.
The issue isn't the amount of time that we had to review Agent Bernie's report about the April 28th incident. The issue is that Detective Racy already testified concerning the movements of cell phones. And and the state seems to be justifying this on some sort of cross-examination. That really the allegation is that Mr. Winfrey was moving with the bus, and the allegation, which I strenuously deny, is that Mr. Stillwell was moving with the bus. Mr. Stillwell didn't have a cell phone, so I'm not sure what the point of any of this is in the first place, much less hearing it for a second time.
Okay.
Yes, Your Honor. During cross-examination, they challenged Detective Racy that he was not an expert and therefore that he could not testify as to what side of the tower that the phone was on, only the tower placement.
Okay.
And because it was specific as to what side of the tower it was on, that's why we asked Agent Bernie to do the analysis based on their cross-examination. I think specifically Mr. Weinstein objected that because Racy was not an expert, he could not testify to what side of the tower that the phone was actually on, which is important given the movements of where the phones were at particular times, the evening or the morning of April 26th. So that's why it became relevant for us to get Agent Bernie to do the analysis, because he can talk specifically about what side of the towers the phone was on at particular times.
All right, which phone?
It was Mr. Winfrey's phone, also the phone that we're identifying as Dolly White or Max's phone. There may be about 3 or 4 other phones that I can't just recall off of the top of my head, but all these individuals were ascended upon the compound, which is where they started, and followed the bus all the way up to the hotel.
Okay.
And then went down to the studio after.
Okay. And does anybody identify a phone as one belonging to any of these co-defendants?
Not.
I can't get this to go back to.
Hey, Nick, good to see you. Traveling and doing more in the United States than us United Statesians are. Americans would be the term, but whatever.
Hang on.
Sorry.
And then Start Pushing Weight Again says, I finally joined the stream and I see Miss Love has one of Johnny Cochran's old suits on. You know, I kind of like the pinstripe look with her. And I don't mean this in like a Cruella de Vil way. I don't want you guys to take it that way, but I think the like business attire, the black with the gray pinstripes suits her style. Like with the haircut and the earrings.
Only phone that he analyzed from these defendants here would be Mr. Williams' phone, because Mr. Williams' phone, we had that plotted that he was in Baton Rouge at the time of this, which was consistent with what some of the testimony.
Okay, so tell me why we need to hear from, and we may, but tell me why we need to hear from Mr. Burney about the side of the tower that other people not on trial hear.
Because it's a part of the conspiracy and it corroborates what other people said about the movement and where everyone was at the time. And because they challenged it so much that we can only say that this is where the tower was, but with no more information.
Okay, and was there testimony, whether there were cell phones for these people or not, was there testimony that X, Y, or Z co-defendant on trial now was with this crowd?
We believe that some testimony will come in soon that Shannon Stillwell, although we did not have his cell phone,
Right.
that Shannon Stillwell was present at the time of the,
Okay.
it has not come in yet.
Okay, all right. So then, with regard to that incident, Mr. Burney's testimony should be on the narrow issue of, I analyzed these cell phones and I can say that it was this side of the cell tower. But we won't need, I would think, to go through, I don't know, but did Detective Gracie give sort of the overview of here's how we know all of this anyway, and here's what, you know? Okay,
Yeah.
so we won't have to go through all of that again. You could just cut to the chase of, yeah, I know all of that stuff too, and here's what else I know.
Yes.
Okay.
Yes.
That works. All right, so moving back to,
Can I ask you a question?
yeah,
Does that exclude then Mr. Williams, who's in another state at the time? We're not going to hear about that again.
I mean,
Am I correct?
are y'all gonna bring that up again?
Because that
Yes,
was
but-
testified
but-
to.
In the sense that he received that document and he plotted that as well. Yes, but we don't have to go into the details of it, but I think it's a part and parcel of what was happening that night
All right, hang
that
on.
they challenged.
Hang on. Did anybody from the defense challenge the legitimacy of Detective Gracie's conclusion that Mr. Williams' cell phone was in a whole other state?
I agreed with it.
Okay, then if there was no challenge to that, that should need to come up again. Right?
Can we ask him whether or not he plotted that phone? Because if he's going to talk about some of the records, we think it important that at least the jurors know he didn't. He
Yeah, I
didn't
mean,
come with the same-
yeah, if it's like that could be like a one question.
Yes.
Yes, and it was in somewhere else entirely, which I would think, Mr. Steele, at least you would like. Okay. Well, that part certainly wouldn't. So you, okay. All right. That is what I said. Okay, so back to
then
the
FFS.
two firearms examiners who are going to be Kelly and YSL, where we can move on from that.
Who would win in a fight, Love or
Silence
Hylton?
is yes.
Love would last longer.
Okay,
She would
so
just
next
keep
is
going
Officer
and going
Zappa.
and going till Hylton gave up.
Looks like, is this one of the crime scene techs?
He's the responding officer to the January 22nd, 2015 shooting at 1007 Hill Street that we talked about
Okay.
earlier.
Any issues with this?
And you're right.
Mm-hmm.
I think it's actually Officer Z Atha.
Oh,
Yes.
okay,
And
there's no
I
space
changed it,
between
yeah,
those two.
and
Officer Alpha. Okay, thanks. Any issues on those photos, images? Are y'all just looking at these now? Okay.
My concern is I don't have any statements from any witnesses. I have the officer responding, but we'll see the next witness that you have on your list. We'll see if there's any more information that we're supposed to get.
we have the police report, Your Honor, that we provided, and then we provided, at least for this one incident, will be Miss Reed, which is the victim in the case, and so that is what we intend on introducing.
And is there a statement of the alleged victim? That's what I was.
Statements are reflected in the report that, to the extent that she gave on site.
I doubt if they can hear her, that y'all just gonna have to pull that mic back over.
Her statements are reflected and memorialized in the reports that were written and provided to the defense.
Okay.
Just so we're clear. My understanding is that the allegation is her home was shot up multiple times. And so we do not have any written statement or any taped statement by any detective, taken by any detective, given by this alleged victim. And so that's what we're asking about. We understand that statements may be memorialized in a report, but we are specifically asking about taped statements, written statements.
Thank you,
Your Honor,
TGQ.
we'll
This is a
double-check,
thing
but
that
just
can
so you know, whatever
happen.
her
I
statements
don't know
is
the
contained
science,
With what she told the
but it can
responding
happen.
officer, and he put in his report.
Okay. And this was way back before body cam was typical, so that wouldn't be unusual. All right. If y'all find something else, obviously provide it, but no, but to their best belief at this point, no, there's not anything. You have everything that there is. Okay, so I'm assuming that other than that concern, there aren't any issues with these pictures that are included, since I hadn't heard any objections directed to those. Is that fair? Fair. Okay, thank you. All right, next is Sanders. I'm not sure what CST stands for, but crime scene tech Sanders. Very good. Also lots of pictures and images of their walking through the crime scene and documenting it. And then the report. Any issues? All right, thank you. All right, moving on to Antrivia Smith. What is that, a video? Okay, any issue on that? Oops. It's a short video, so even if you're watching it for the first time now.
I was under the belief that they were going to introduce this video through Mr. Sledge, but
All right, hang on, and nobody can hear across the courtroom if we don't talk into the mics. I know it's annoying, but
We have it coming in through Mr. Sledge. That's why we were just pausing, because it's already been an exhibit that's identified as coming in through Mr. Sledge, but it was Ms. Smith who gave it to the police following the shooting of her apartment to show the antagonism that existed between Mr. Sledge and YSL and Mr. Watts, whom she was also seeing. So that's the reason that it's in both folders.
I would hope
Both
questions are
buckets.
not articulated that way in trial, because it's Mr. Sledge arguing with another man over a girl. I don't know YSL how that fit in, but
Pull it out, shirt.
I think.
okay, well, that may be, it probably will. And if it's presented that way, then y'all will have some good subject matter for your cross-examination.
That there's Mr. Sledge, since it was mentioned, Mr. Sledge said, oh, no, it wasn't over a girl. We
Okay,
weren't beefing over a girl.
all right, well, they'll say whatever they're gonna say, and y'all can examine accordingly. All right, Sharon Latner's. These would be the CAD reports, I assume. So we'll hold those for tomorrow. Does that work? Okay. And tomorrow, y'all can tell me what parts of, if any, of those y'all think might be excludable as hearsay without an exception. All right, we are moving now, at least theoretically, to a different overt act, I think, right? So now we've got crime scene tech Turner. And that folder is empty, at least on for me. Do y'all have something in y'all's folders for that? They're empty for y'all too? Okay, well, maybe that was just a mistake. Is there supposed to be
Yeah,
something in that folder?
FFS reminding us we can't talk about drip anymore because it's a gang term,
All right,
according
we'll
to
come back to
law.
that one. Y'all check on that tonight.
And it's a green suit.
And that may have been the ones that they told us that APD no longer existed. It may have been the ones that we identified and told the defense about. There were about 127.
From the hack from whenever
Yes,
that was?
we had asked them for the physical copies, if there were any, because they said that the digital copies did not exist.
Okay.
And so that, I think that those were, it was Turner. It was Turner's
Okay.
photos that were those photos that we
Okay.
were trying to
Those
get.
were lost in that several year ago hack.
The cell tower in the
So
chat.
That's why that's.
That's what the photo.
Keep my name out of it.
All right, moving to Jenkins. And these are just crime scene photos. Pretty standard. Any objection on those that y'all anticipate? Okay. All right, Tyrone Dennis. All right, let's walk through it kind of one by one. All right, so the first thing is what's identified as States Exhibit 71, Act 78, and then the lyrics to Bad Boy. All right, what's our objection? And this is only if this hadn't already been litigated. If it has, it has.
Mr. Williams doesn't, these are not his writings.
Okay.
Somebody, Google, I was told Google, just put them down. I'm not telling you that they're wrong, but I'm certainly not telling you they're right. But it shouldn't come in this form. This is not how Mr. Williams made a song.
Okay.
So I would be objecting to the best evidence rule. And I don't know why, I don't know if the state is planning to hand it out as an exhibit to the jurors, flash it on a screen, but I don't believe that this is proper testimony. In addition to that, Detective Dennis, for him to claim here are lyrics and here's what they mean, I don't think he has any basis. I've asked him whether he,
Okay.
when he was qualified, you know, whether he spoke with anybody with the lyrics, how he makes the lyrics. He has no idea. He's just a listener.
Okay.
So those are all my, but those are, I raised those objections previously, but
All
we
right.
were arguing.
And, sorry, go ahead. And what?
And the court stated he made a preliminary finding, the prior court, that lyrics are admissions, confessions, co-conspirator statements, and if a proper foundation is laid, then he will decide later if they come into evidence. That's
Okay.
pretty much how
Thank
it
you.
was.
All right. So the best evidence objection y'all might need to deal with.
Your Honor, we would be, as far as the displaying or the publishing of the song and the lyrics to the jury, we would likely be doing it through Mr. Williams' words as he speaks them, and we may have a accompanying, it can be typewritten, whatever, transcript of the lyrics, however it is that we intend to display it, but that we can also provide to the jury in terms of their ability to more easily hear
As a
what is being said.
I feel like they need
demonstrative aid.
transcripts
Yes, and
because
as-
Glanville
and as
said
far
no
as
to
the
some of
objections
this.
as to the meaning behind certain words or lyrics. Detective Dennis would be talking based on his expertise in certain areas, particularly as a gang expert,
Mhm.
as to certain meanings or certain language. But if there isn't, you know, if there's a different interpretation or if someone else intends it a different way, then that's, we would submit as the area for cross-examination or a different testimony from the
Okay.
person who's seen.
All right, well, I think that with regard to something being used as demonstrative aid, you need to make sure it is the correct transcription of what the lyrics actually are. It does not need to be pulled off of Google. I mean, if you want to pull it off of Google, you can, but it doesn't need to look like this. And please provide it to Mr. Steele and Mr. Adams beforehand so that if there are any disputes as to what the words actually are, those can be dealt with. And then I would permit Detective Dennis, if he's been qualified as a gang expert, to say, you know, in my expertise, this might mean X, Y, Z. Obviously, it doesn't mean that is what it means, but that's his opinion of it, which the jury can accept or not accept. It's up to them. And of course, he can be crossed as to how on earth he might know that and, you know, all sorts of good things, I imagine.
I guess it depends on the lyric, but intention can never be discussed by an expert, a person's intention, because it's
Sure.
not beyond the ken of the
Agreed.
jury.
I mean, yeah, I wouldn't let him say, here's what Mr. Williams meant when he wrote this lyric. Just this lyric in common gang parlance, we believe means whatever. Okay. All right. All right, the next is Exhibit 72. The same, it's basically the same thing. It's just another set of lyrics.
Yeah, the
Okay.
jury's gonna
Your
like
Honor,
think about
one of the
songs they
things when we're
like
talking
and
about
be
the lyrics
like,
that I think I need to bring up right now.
Okay,
I believe that we are going to be asking for a limiting instruction.
okay.
I don't know how the performance of music, I mean, the state is fighting us tooth and nail saying YSL is not music.
Mhm.
So I don't know how that at the same time putting out music could be in furtherance of a conspiracy. So
okay, Shart.
I would think that the lyrics can only be considered in regards to the person who is the source of the lyrics and not the other people sitting here.
Judge, I think that we,
Mhm.
so one, we've never made the contention that YSL members do not rap. We have repeatedly asserted
Yep.
that there's that aspect of the game.
Mhm.
So that's not true at all. And I believe that the issue of who it comes in against has already been litigated. I will make certain, looking at the order that Judge Glanville has entered, but there's no limitation as to this only comes in against Mr. Williams because he's the one that said it. It's not a testimonial statement. We would argue it's at the very least a co-conspirator statement, but and at times there are adoptive admissions, at times it's a party opponent, but there are various hearsay exceptions that allow these statements in. And Judge Glanville, we're looking at the order, but I believe Judge Glanville specifically ruled that they come in as co-conspirator statements. We'll look back at the order he wrote and entered after our very, very long hearing
Okay.
on this matter.
Okay, well, y'all.
This is a good point,
let me
Julie.
know
Like,
about that.
Whitaker should really watch Dennis on the
And
stand the
if
first
y'all
time.
want a limiting instruction, you can certainly propose one and I will take it under consideration. And, if it's a blanket, every bit of this is a co-conspirator statement, that's one thing. If some of them are one exclusion and, one exception and some are another, I'll just have to look when I'm considering a potential limiting instruction.
And Judge, also, when we intend to enter certain statements made by certain of the defendants in that they have put a beat behind, we don't intend to play all of the words to all of these songs by any means. So we'll extract the words that we intend to introduce and make certain they're aware of those and
Okay.
tailor those to the order that has been entered in any order that rulings that the court makes.
Okay, thank you.
This just seems like when they try to play it, there's going to be more objections then. But Sheeny
All right,
Beanie, I
so
get where
our
you're coming from.
exhibits
Push back harder, defense. We want to see some primetime legal
Down through
drama.
79, also lyrics.
But so much of this is, oh, we'll deal with it when you try to introduce it. We'll deal with it when you ask that
Okay,
question.
so, sorry, then.
Which kind of makes us feel
71 through
timeless.
77
I mean,
are all
pointless.
lyrics. Okay, so the ruling would be the same as each of those. All right, so now we'll turn to 79, which I can't seem to open.
It's a picture.
Okay,
I can share as well.
okay, thank
Want me
you.
to share a turn?
Sure.
And then I'm sure like a lot of the songs they want to introduce probably have multiple writers credited. Like,
Okay. Okay, it's already in. I couldn't hear you. What'd you say?
okay, so that's a post from
I believe
Scarface.
that's in already. We agree.
Okay, Mr. Steele, did you say something about Bruton?
That's what I'm reading, but no, I said the same thing as Ms. Adams.
Okay.
I cannot be 100% sure, but I
But
believe
y'all,
it's.
all right, well, if several of you over there think it is, and y'all think it might be?
The caption may not be.
Okay, any issue with the caption?
Not 100% sure. I believe it's in, or at the very least, it's been testified to.
Okay.
But I
Thugger
guess
Thugger
when
1 say we
find
ain't
the,
going back and
the
forth.
original-
All right, y'all can let us know on that one then.
Judge, did we reserve on, or in some of the 71 through 77, because we were going to check the order, Judge Glanville's order? I want to reserve on 74.
Okay, yeah,
And-
we did. We're gonna
Okay,
get the order and then come back to that.
all right, thank you.
Thank you.
Wait, where was this? This is a comment on that post? I missed it. I was only like trying to read the caption itself from Scarface.
Sorry, y'all. Somehow everything got closed, so I'm opening it back up. Okay, so then next would be Exhibit 82. Is that already in by chance?
I don't believe it's in. I believe we've discussed it in regards to another witness
Okay.
previously. I don't have any problem with it personally.
I think we talked about this.
I think we've already dealt with this. All right. States Exhibit 83, what is it, Lima LL? Not that up on my neo-phonetic alphabet.
Guys, and
I
my
got it
thoughts on
right.
lyrics
Maybe
are like if
not.
that Joyner Lucas song, Ross
What is-
Cappuccini,
I mean,
was
I know what this
actually
is, but
written by
what
Ross,
does this have anything to
then
do
it's
with-
very specific. It sounds like an admission. But it shouldn't be used against Joyner Lucas, who's writing it as sort of a ballad.
Yes, that is the gun that was found at the Dunbar Center with Mr. Copeland.
All right, any issue on this?
Not if there's an appropriate testimony to it. So no, I don't anticipate any issue.
Okay, so I imagine, obviously, they'll have to establish that's what it was, but assuming that is established, that can come in. Bless you. Okay, and then 84 Lima A. Any objection?
The good point, destined to be, they played hours of Woody's videos, non-interrupted, but now they're picking out
Is this
lyrics.
the black and white picture, Your Honor?
No, this is a video of a club.
So this is, Your Honor, September 30th, so the night preceding the October 1st over at with Mr. Kendrick and Mr. Arnold, where Mr. Arnold gets into a fight at Magic City. This is a video of that. And that's also 84, it's 84 LL, A and 84 LL.
Okay. Any issues? Evidentiary issues?
Not assuming they can lay the appropriate foundation.
Okay. So okay, LL is just a different view. Okay. So, and then there's another 84 LL
LL and then 84 LLA.
and then another 84 LL. Maybe that's a still? I don't know.
Let me see.
Oh, no, that's a gun. Maybe
So, okay.
there's a mislabel.
There's a
maybe.
mislabel, Your Honor.
Okay, so whatever that gun is will need to be
A different label.
a different number, but I assume that's some gun that's some way tied to something.
Yes, that's the gun, Your Honor, that was found on Quindarius Zachary when he was at the gas station.
Alright.
That's it.
Okay.
Quindarius Zachary.
Then we've got 85 through 90 LL. Any objection to any of those?
One of them, we've already. So 85 LL is the interview of Mr. Kendrick.
Okay,
Yeah, and we've already dealt with
All
the PowerPoint, which is 86.
all right.
87 as well.
We've dealt with 87 already?
Yes. 'cause
Okay.
that's-
Oh, yeah, that's, okay.
We've not dealt with 88.
88. Any objection to 88? Evidentiary objection?
I'm sure we'll be objecting to the commentary on this posting.
Except for the ones by Mr. Stillwell, I suppose, because Mr.
Yeah, I don't know the explanation on what to do
So-
about a ghostwriter. Like, that's the conundrum.
Yeah.
Someone else could
We
have
were
written
having
it, so how
problems
does that
with
explain
anything
intent?
Mr. Stillwell doesn't post.
Or an admission, whatever.
Okay, yeah, I mean, that's going to be done for all of these kind of Instagram-y type posts anyway, right?
Yes.
Okay. All right. Yeah,
If the state would educate me on the relevance of Mr. Stillwell's posting there,
okay.
what
so-
they think it means, because I mean,
All right.
I'm not gleaning too much from it.
Okay, there's a relevance objection.
All right. So, Judge, we are alleging that Mr. Stillwell is a member of and a participant in a criminal street gang and a criminal enterprise known as YSL. His donning of these red bandanas, one on his right hand and one over his head, and his use of welcome to be that red bee with the red heart, Dave Paradise, on March 28, 2015, during the year or the relevant time of this back and forth that was going on, are all relevant to the allegations made in the indictment. So with relevance being
Your Honor,
the bar that
I
it
misspoke.
is.
Hang on, don't interrupt.
I'm withdrawing.
Oh,
Oh.
okay.
I misspoke. I thought they were saying that someone replied to Mr. Stillwell, and I thought
Okay,
they were
no,
saying that was his
She's
post.
taking all that off.
Okay, all right, I'm good, thank you.
All right, thank you. I think that's 100%. Anyway, not a heart. Had to get my glasses out for that one, but
I
I
could
think the argument would be the same. Okay, so that objection's withdrawn. Long as, yeah, you just need with all of these to take off the comments. Same with 89.
Yes.
Any issue otherwise to 89 LL or 90 LL? Well, 90 LL is not a photo, it's a video. Any objection to either of those?
Your Honor, as long as they keep
Hold on. So this Bohemian Rhapsody chat going on in the chat is great. It's a great example of the different interpretations and why rule of completeness is important. So we have two, and I'm on the side, I interpreted it to mean that opening line with Bohemian Rhapsody, Mama just killed a man. To me, I read that as Mama, comma. This is who I'm speaking to. I'm speaking to my mom and I'm telling her, hey mom, I just killed a person. But there's other interpretations conflicting with mine that say, oh, I thought it was mom that actually did the thing. And the singer is just describing it. And then Jim, CSI, comes in with the mama, life had just begun, but now I've gone and thrown it all away. So if there was debate, if the jury could interpret that opening line of Bohemian Rhapsody either way, and they didn't get to see this further line with Jim, I've gone and thrown it all away, they might be left without the clarity because they're not seeing it completely. So great example, Bohemian Rhapsody, for this example of when you're using song lyrics and you're trying to introduce tiny little segments of a song and not the whole song, how it could change drastically in a prejudicial manner the way that the song is interpreted. Good stuff, you guys. Look at the chat. I love the chat.
my client's comment on that exhibit as well, where he
Yeah.
sarcastically says we beefing, mocking the idea that there's gang rivalries.
Are we talking about 90 LL?
We're talking about 89 LL, right?
Okay.
I don't actually see that.
He doesn't say what his client says dripping through Cali with some real ends at Gotti with that red B. His client is not listed under the 6 comments that are going to be taken out.
Is there like some comment later that isn't shown maybe? Because I don't see it on this.
Yeah, but I think he's talking about, correct me, the first comment says at SB with the we beefing, but I don't think that that's Mr. Stillwell. That's
Okay.
the other person posting that she's beefing with him.
What's going on is
Mhm.
these comments are in dark blue on the black background, so I'm
Right.
only seeing the white. So I'm seeing my client commenting we beefing, which obviously would be sarcastic. He's sitting next to his friend, but now I see the blue, that Okoye having her way posted that, so.
Yeah. Okay. All right, how about 90 LL?
We'd be objecting to 90. I don't know what the relevance is of
Okay.
90
All right, there's a relevance objection to 90 LL
and 403.
and 403.
Judge, I think it's best if we just play this
Okay.
one.
Little slam. YSL. Crip killer.
That's Mr. Williams's voice,
Based on?
directing,
Let's not interrupt each other, please.
directing this child to throw up these gang signs. So that's what.
So are you going to have some kind of either somebody familiar with Mr. Williams' voice to say that's him or a voice analyst to say that's him?
We would have someone that we believe is familiar enough with his voice to say that that's him.
Okay, well, we'll see.
We have Mr. Stillwell, we're going to ask for a limiting instruction, if that's admitted.
All right, proposed one, please.
On behalf of Mr. Williams, Your Honor, what
Mhm.
is the import of this? So I understand it's prejudicial because a person may think that a young child using what I would consider gang language with their hand signs may be inappropriate, but why would this matter here? The lyrics are coming in. Mr. Williams is constantly changing the letter B to, or letter C to a B. Like instead of Cleveland Avenue, Believeland Avenue, there's a whole bunch of lyrics that Judge Glanville let in. There are tattoos on Mr. Williams' body that has already come in that shows the letter B and alleged other supposed gang symbols. They have introduced, they being the court has admitted into evidence exhibits showing things like a green snake or an emoji with a B on it. I just don't understand why the child is an important part of this mission to find the truth here. And Mr. Williams' voice, I find it to be wholly prejudicial, and I find the probative value to be scant.
All right, let's hear from the state.
So, Your Honor, as the court is aware, the rules of evidence are rules that favor admissibility, and 403 should only be used in extreme situations. And Mr. Williams, not the state, bears the burden of showing when something is shown to be relevant, it's presumptively admissible, and he bears the burden of showing that its prejudicial effect substantially outweighs its probative value. And Mr. Williams has said nothing about the prejudicial effect of this video with his child, with Mr. Williams dictating to this child, throw up B, YSL, Crip killer, which are all things that Mr. Williams has attempted to distance himself from throughout the entirety of this trial. He has asserted that all of this is, not real. All of this is, just a facade. And the more that the state is able to show to the jury that this is, in fact, not a facade or not someone pinning on Mr. Williams' designations that are not accurately pinned on him, then the stronger the state's case becomes. So our argument is that Mr. Williams has in no way shown that this video is substantially more prejudicial than probative.
All right.
Your Honor, with respect to Mr. Huey, we would also chime in on the 105 instruction, but notwithstanding that, Your Honor, can you hear me, Judge?
I can hear you. I don't think that's working, but I can hear you anyway.
Can you hear me now, Judge?
Yes.
So we would also ask for the 105 instruction on behalf of Mr. Huey, but notwithstanding that, Your Honor, this is extremely prejudicial from the standpoint of having a child hold up these gang signs and so forth and so on, what appears to be gang signs. And again, this is going to be one of those scant and cumulative aspects of a piece of evidence that if the court allows it to come in, it's going to be drug in for the sake of its prejudicial effect. Clearly what 403 says we can't do. So I would ask the court to take that into consideration.
Okay, well, I'm certainly considering the appropriate law. Yes, sir, Mr. Steele.
There's also another, I can't find the exhibit number, but there's a video that came in over objection that Mr. Williams is doing something similar, or someone's doing something similar with a child.
All right, why don't y'all get me that and I'll consider whether there might be a cumulative issue here. But with regard to just 401, 403, it's certainly relevant, and I agree that it's prejudicial, which, you know, case after case says most of the state's evidence is prejudicial against defendants. I don't think it's substantially more prejudicial than probative, considering part of the conspiracy they allege is preserving, protecting, and enhancing the reputation, power, and territory of the enterprise by the posting of messages, images, videos, and songs demonstrating alignment to the enterprise and a willingness to engage in violence on its behalf. I mean, it's wildly probative to that.
And Your Honor, we're also going to ask for a Rule 105 instruction on behalf of Mr. Kendrick. And we echo the comments made by the others.
Okay. Yes, ma'am.
We don't believe that a 105 instruction on this type of evidence is appropriate. It's not a testimonial piece of evidence, a testimonial statement. So we would ask that a 105 instruction not be given in instances where this is the evidence being presented. And we would also submit that Jeffrey Williams is alleged to be the leader of this gang, and in having or directing this child and other children to do things like he's doing, he is, in effect, he's starting early and starting young. That is part of the state's theory in this case, that this gang recruits young children, and this is what it ends up being.
Judge, I think there was a piece of evidence that came in on, or we reviewed a child on yesterday, if I'm not mistaken, that we saw in an image. It was either posted.
Yeah, but I don't remember that being anything that the child was doing in response to somebody directing them to do it. I think it seemed like the child was, I mean, I'd be happy to look at it again, because that's not specifically what I was looking at it for then. But if that's what y'all are thinking about, you know.
Well, that's one at least that immediately came to my
Okay.
memory.
And do you recall that child was doing that in response to somebody directing them?
I'm not sure if there was sound associated with that particular image, but it was certainly at the direction of an adult, and then the child was.
Was it Mr. Williams?
I believe it was.
Yes, Judge, it was. It was the one of the two videos that you saw on yesterday, and when you listen to the sound, it's exactly the same thing. The child is being directed, and in fact, it's the same child.
Okay.
He says big B, little b. He doesn't say Crip Killer. He doesn't say YSL.
All right. That is not cumulative, if that's the only one that y'all had in mind. So that's, I'm overruling those objections. Okay. I think that takes care of that witnesses exhibits, at least for now. Martinez Arnold. I see there's a plea agreement in that one also. On same grounds as before. Is there anything in particular on that one? I know there was. This isn't the same one we talked about before, is it?
No. Mr. Sledge.
Okay.
It will be similar ground. You know, he's testifying, so why do we need a plea agreement? And the state wants to put it in, my understanding. And it would be continuing witness because it's a statement, and he could testify to whatever, and then he can get impeached.
All right. Well, continuing witness is only about whether something goes out to the jury or not.
Correct.
So that's not relevant to whether it actually comes in or not. And then it's the state's intention to use this only if you need to impeach him as to something? Correct. Okay.
Correct, Your Honor. And if he's truthful, then we don't need to accept, you know, I mean, if he's truthful, then we don't need to go and show and introduce this as an exhibit. And I'm assuming they're talking about the factual acknowledgments, not the,
I don't know.
not the conviction itself.
I don't know. Let's
Shout
find
out to
Are you
recuse
talking
Judge
about the factual
Glanville.
Acknowledgements?
I am talking about
Leaving
factual
bots out of
knowledge.
contempt,
There has
Mr.
to be
Bots.
proper purpose for the guilty plea, which there could be one, but I didn't hear it yet.
All right. Is there anything about the factual acknowledgements here? Like, I know that last one y'all were saying, I don't think this person has any firsthand knowledge. Is there anything like that I need to look at in particular? Okay. All right. And so for these people, you just intend to have them admit they pled guilty? Okay. So this wouldn't be relevant at all unless they say, no, I didn't, or no, I never asserted
Right.
that fact, or
So-
this would be.
So this, right, or that he was forced or he didn't
Right.
know what he was doing.
Right.
I think the certified conviction might actually be proper evidence. I need to think about that, but as far as the other stuff that they're
I
talking
mean,
about.
yeah, and you can certainly, I guess, tender that if you want to.
Yeah, but
Um,
the other information is only, as we said earlier, if someone isn't truthful on the stand.
Right. Okay. Thank you. All right, the next item in there, I can't open, so I don't know what that is, but if y'all can open it and
Thank you, recused Judge Glanville,
you
for
know what
reminding
it is and
people.
don't have an
Hit the like
objection, then
button,
doesn't matter,
or you'll
then
be
I can
held in
open it.
contempt. With everybody
Your
except
Honor, we're
Mr.
talking about the third one
Botts.
down?
I was talking about the second one down because I don't know what that is. The one labeled like NT, Fulton, CODA, and then some numbers. Oh, okay. Don't know why I can't open it, but we've already reviewed that one. Or no?
So this is a transcript of an interview with Mr. Arnold, and there is no need to enter this or use it unless we need to impeach him.
Okay, and I assume it's a certified copy that y'all would use if need be. I mean, I guess it wouldn't have to be, but
It's not certified?
Okay.
You mean of the transcript?
Yeah.
It's not certified. It's just a.
It's a hallway conversation.
say that again.
It's a hallway conversation. It's not-
Hallway
it's not in
conversation.
court.
It's
not like-
130 page,
Court reporter
transcript
alarm
of the
going off.
conversation.
Oh,
Interview.
it's not a transcript of the guilty plea.
Right, no, it's an
Okay,
interview.
Thank you.
It's an interview. That's what I was saying. It's
Okay.
an interview.
It's a transcript of an interview, which you don't assume you'll be using unless you have to refresh his
Impeach.
recollection or impeach him.
Right,
Okay.
that's what I was saying.
All right, no problem. How about this next thing labeled recording?
And let me just say, I don't know what Mr. Arnold's going to testify to or not testify to the extent that the state is ever planning on just playing I understand targeted impeachment,
Mhm.
but, and if I've fallen short of expectations, I apologize, but I have not reviewed this transcript for any extraneous, irrelevant,
Okay.
prejudicial.
And yeah,
things.
and thank you. Y'all don't intend to wholesale use that. If you did, that would be a problem. Needs to be targeted. So yeah, just regular old trial evidence. Okay, thank you. All right, and this next thing, which is maybe some sort of a musical recording.
Interview itself.
Ah, okay. I opened it up and it shows a musical note. I guess that's just my media player. Okay. And then this last thing is a picture.
Photograph, yes.
Any issues on this one? No? Okay, moving on to Officer Munson then. Looks like there's another set of crime scene pictures, maybe. And a crime scene report. Couple of crime scene reports. Any issues on those?
Don't anticipate any issues with the crime scene photos.
Okay, thank you. All right, moving on to Jennings Kilgore. We're almost to the bottom of this grouping of 30. This seems to be a ballistics expert.
NIBIN expert.
A what expert?
NIBIN, National
Okay.
Institute of Ballistics.
Okay.
Immigration.
He is a
something that-
ballistics expert with a
NIBIN
particular,
is different.
it's a big time one, right?
It's the one right before. It's not the actual firearms examiner. So it's a step before. It's a comparison to see if these have the same characteristics.
All right, anyway, anybody have an issue with the evidence that's gonna come in with this person?
I'm sorry, what is this? This is under, trying to find out specifically where it's under the NIBIN reports. I don't know if I'm pronouncing that right. NIBIN charts. There's a document labeled Operation Planters
Okay.
NIBIN chart.
Okay, I can't open that one either, but
Yes, and that's a summary of
Okay.
NIBIN matches that were.
I'm having trouble seeing it in detail, but
yeah, maybe because the black on the blue is a little hard to read.
Oh my gosh, she's criticizing the
all
graphic
orange and
design
have orange.
choices. Hilarious.
So is the question just kind of like, what does that say?
What is that?
So those are the chart with the black on the blue. That one is showing that there were 5 shell casings from a particular scene. The black on the blue is the address.
Okay.
The red lines are matches to other addresses where shell casings consistent with the firearms at the previous address were found.
Okay.
And there was, I think that we served in discovery, but I don't think we included in this list of exhibits. There is also an ATF NIBIN examiner that we didn't have in here that they also examined some of these shell casings from different sites. Both Kilgore at the Atlanta Police Department and ATF were all working in conjunction with one another. So
Okay.
there is one more person that we'll be adding to that, but we'll let them know well before we.
All right, well, if they're gonna say the same thing, we don't need them both.
We won't have.
All right, so with regard to this kind of chart, I guess, now that you know what it is there an objection?
I have one.
There they go again.
Well, here's the problem, Your Honor. And before you were involved in this case, a lot of these prior incidents were Detective Dennis took the stand and the state brought out an easel and they wrote down all these different case numbers and they went through them real quick. On January 26th, 2015, there was a shooting at 841 Smith Street. I'm just making that up. Okay. And in this, and as a gang investigator, I determined that was part of this beef. Okay. We for a lot of these incidents, we have not heard from any witnesses that collected shell casings. There's been no chain of evidence. There's been no testimony about the collection of evidence.
Okay.
So this is just like coming in without any basis or any foundation, and it would all be hearsay.
All right, is
and
he?
violate the Confrontation Clause as
Okay,
well.
is he gonna be testifying that he received the shell casings from each of these and did the exams, or that other person from ATF that you mentioned, or how is this gonna get used?
When shell casings are collected, the first person that does that comparison is either Kilgore at APD or they're taken down to ATF to do that comparison. What Kilgore or the ATF NIBIN person would say is this shell casing here was consistent with or had the same general class characteristics as this shell casing over here that was found at this scene and produce what we call a hit.
Right, so is Kilgore gonna be able to testify that for each of those blue boxes, he did an examination or comparison, and that's what he came up with?
Yes, for everyone that we have a match for, either Kilgore or ATF, Kilgore or ATF did that initial NIBIN comparison. I'm not sure if what the objection is. If we're not going to have him talk about something somebody else did. If that's
Thank you, FFS.
Okay, so I think one of the objections is that thus far, we have not heard shell casings were collected from this firearm scene and provided to Kilgore, and then Kilgore obviously would say, yeah, I got them and I did this evaluation. Is that all of that foundation is going to have been laid in the evidence by the time he gets here to testify to this?
Yes, that's why we have the crime scene technicians coming up, talking about what they collected.
So it sounds like by the time we get to this, that will have been done.
Be a two-way connection though. It can't just be we collected, I'm using an example. We collected, certainly we've had the crime scene, or we will have had the crime scene technician, I believe, from the January 10th incident. So we'll know what was collected, and it was sent to Kilgore and it was sent to NIBIN, and we get that. But if they're going to say, well, it matches another crime scene, the expert in the lab can't say that unless we know. They can say, I guess, presumably it matched another bullet in the database or something like that. But unless there's a link to an individual crime scene, yes, we collected this and it matches up, that's still based on hearsay. Kilgore or whoever the expert in the lab would be testifying based on hearsay about where that other ballistic evidence was collected from, unless we hear from the person who collected the evidence.
And we would. So I don't know why, I don't know why we're arguing at this
But
level.
we're not arguing, we're trying to clarify. So
For the
instance,
other
and I can't
related
see them,
match scenario, love.
the very top two on there, you know, they apparently say, okay, this crime scene A and crime scene B. We will have, and this person, Kilgore, will be able to say, I did a comparison of bullets from crime scene A and bullets from crime scene B, and they're consistent with having been shot from the same gun or something similar. The question on the floor is, okay, will we have already heard not only the chain of custody for Kilgore getting the crime scene A bullets, but the chain of custody for Kilgore getting the crime scene B bullets?
Right. It
Yes,
sounds
so
like the
we would not
defense
have-
hasn't been disclosed crime scene
Yes,
B
all of the
matched
foundation,
information.
I don't think chain of custody, like, you know, specific, like every link in the chain would be necessary, considering we would have the crime scene technician who would have collected it. We would have the testimony that when the crime scene technician has collected it, it comes to my department, my being Kilgore. This is the case number 150261534, and I compared it to case number X.
Okay, so we will have both, just so I make sure I'm understanding you. We will have a crime scene tech from crime scene B say, I collected all of this and I gave it to the crime lab or whom, I don't know if this is.
I put it in,
GI
I
or
put it in
whomever.
evidence.
I put it in the, box or whatever they do. And then we'll have Kilgore say, here's the way evidence gets to me and this got to me that way.
Yes.
It sounds like
Did I answer
defense
your
doesn't
question?
have this part B information disclosed
I
to them
guess
right
it's yet
now.
to be determined whether we will hear all of that evidence, but the objection is going to be, if we don't hear all of that evidence, he can't testify to this. So do you understand that?
I'm sorry, Judge. The objection is that
If we don't hear the foundation that is both crime scene A tech giving the evidence to Kilgore and crime scene B tech collecting and giving the evidence to Kilgore, and then Kilgore saying, I got them both in the regular course and I compared them, here's my conclusion, that there's going to be an objection that he can't testify about crime scene B.
and to make certain, looking at the witnesses that we had initially put up, what we can do is add the 10 witnesses from each of those crime scenes that are on this list to make certain that we have each of those links
Okay.
included as
Sounds like
evidence.
that's going to have to happen. Now, it does not need to be, I don't think, a whole is if this were the crime on trial.
It would just
It
be,
can just be, I'm a
hi,
crime
witness
scene
number
tech.
1 through 10 that I'm adding on. I collected
I
this
went to
one.
this crime scene at this date. I collected
Right.
this evidence. I gave it to whomever.
Right.
There's
Which
no
she-
way that the defense
Ten-
has been
10 days.
disclosed this
Okay.
information then, if
All
they're
right.
coming up with it now.
She plans to now do all of that. Unless y'all want to stipulate that those bullets got to the crime lab in the normal course from whatever crime scene, which I don't see happening. So, okay. All right. So anything else with regard to Kilgore's, the evidence that would come in through Kilgore?
I feel like Love deflected to the chain of custody being established to avoid the fact that she never disclosed where the
Then our
matching crime
witness
scene
number
is, what it
30
is
on
to the
this
defense.
list is Underwood.
And I think the
Is
defense should
Underwood
have dug
also
into
a
that.
Ivan expert?
She's not. She's one of our and detectives and gang experts in this case.
Okay.
And she actually may have been the one, she was an ATF task force agent, and she also would have been instrumental in taking some of the evidence over to the task force versus APD's ballistics lab where Kilgore worked
Okay.
to have it tested over there.
Okay. Any issues with her evidence?
Yes, because it's going to be repetitive. She is an APD officer, and she's going to be supposedly or potentially the same treadmill of information about YSL and if gang, and this is what the policy is of the City of Atlanta Police, why we qualify people in a gang, and we've heard it from Detective Belknap, Detective Gaither, Detective Dennis. They have 5 gang experts allegedly from the same exact, they work together.
Is this a
So she
gang
is-
expert?
That's what I said.
She may be
She's-
a gang expert, but is she going to testify as a gang expert?
I don't anticipate getting into anything overlapping. And actually, we were, before this last conversation, thinking of not calling her at all.
But, okay, so she would be chain of custody only?
Some chain of custody. And at this point, I don't anticipate calling her as another expert. But as far as the gang experts are concerned, Your Honor, I just point out that what we've done is announce to the court and to each of the defendants that our gang experts would not be talking about overlapping pieces of information. Every expert was talking about a different point in time
Okay.
as to their knowledge.
Okay.
Detective Underwood had an earlier knowledge of this particular street gang than did Detective Dennis. Detective Belknap testified to a different slice of time.
Okay.
Detective Dennis and Gaither were two people who worked as partners during the same period of time. But when we are alleging that this is a street gang that has existed from 2012 up until 2022, during the time of this indictment and even afterwards, and we have every step of the way had cross-examination questions and the rebuttal assertion that this is not a gang, this is just a music label, and none of what you see really amounts to what the state is saying. To have gang experts who are having expertise in particular cuts of time that the gang existed is not cumulative. And the very fact that some of what they say overlaps doesn't in any way make what they're testifying about so cumulative.
I understand. All right, so has this person already testified as a gang expert?
She's not, she's just been qualified as one.
Okay, so you do not anticipate having her testify in her gang expertise role, just as custodian of whatever this evidence and getting it from one place to another then, is that right?
At this point, like we said, at first we were, and then we were like.
All right, and I would think that if for whatever reason you decide that's something you think you need to do, let's address that, because I don't think we need to hear, and I hear you saying we haven't heard the same thing, but we don't certainly moving forward need to hear the same thing. So, okay, that's clear. Thank you.
Your Honor, as the state is announcing that she's just going to be, Investigator Underwood is just going to be a kind of custodian of, or transferring evidence from one place to another, I assume that the operation planner's NIBIN chart and the operation planner's NIBIN leads new chart will not be introduced through her?
Well, none of it's the same or substantially similar to what will be introduced through Kilgore.
I agree. I just noticed that in the folder.
Yeah, I mean, they do. Again, I don't know why, but I can't open a lot of these on this computer, but is that the same thing or is that something different?
It's a colorful picture showing like a flow chart involving the information that Kilgore has.
Generally the same?
It's all the same information. It's just presented.
It's more colorful?
Yes.
I mean, pick one or the other. Okay. All right. Is it easier to read than the other one?
It is.
Okay. Well, you can always switch the witnesses that you were going to use that for, but yeah, we don't want to see it twice, but okay. All right. That gets us through our first 30 bucket.
We haven't done Mr. Sprinkle.
Well, yes, other than Mr. Sprinkle that everybody wanted to come back to. All right. Trying to just look back through at things we need to revisit.
What if like tomorrow they're like, oh, we're going to change
the
the order of our witnesses, of our next 10 witnesses?
Okay, so I think this is a good place for us to stop today. And then, tomorrow, other than the potential hearsay and CAD reports, which we can take up, we can either move to the next 30 and do the same thing with regard to them, because they're going to have to be done at some point when the jury is out. Or y'all don't seem to want to reach the wiretap stuff yet, but as quickly as y'all can specifically identify that and get it to the defense, then we can get to that. I think it'll be easier once they actually have targeted information about that. Yes, sir.
Know why necessarily, but the state specifically identified jail calls for my client as they've stated, which is I believe 13 or 14. I've reviewed those.
We're right. Okay, so tomorrow we can tackle those.
And I'm just warning everyone, other people, not in a, I'll just say it affects.
Alerting everyone.
I'm alerting everyone that it affects more than just my client.
Okay, so everyone might want to take a close look at those.
Please give me some
Before
backup.
tomorrow.
I'm tired of looking through these call time logs.
Okay, anything anybody needs to put on the record, make suggestions about for how to be efficient tomorrow, anything like that?
Your Honor, it's State's Exhibit number 55W, which would target the child with the hand signals.
Okay,
If you can, it's 55W has been shown to the jury.
would it be easy for somebody to pull it up on screen for me? And is this just a still photo or is this a video?
A short video.
Okay,
It was played for the jury.
all right.
And yeah, FFS, it definitely seems like 2 lies and a half truth.
Is Mr. Kokomo going to play that for us, or is I don't see him anymore? I think the state's going to try to find it.
Yesterday, I just don't remember that, but it's one that was played months ago. Yeah, you come outside the house.
Okay.
I have another matter while the state is
All right.
helping us. Can I just tell you a case?
Mhm.
Okay, so I believe that my concern about when it's dealing with the RICO conspiracy in Bruton, and then the person in custody is giving a statement, confrontation clause statement, talking about the enterprise, let's say.
Okay.
I have found that my argument has been rejected. And this is the 11th Circuit, United States versus Espinosa, ESPINOZA. It's 635 Fed FED period APPX 739. It's in Division B as in Barry. And it's 11th Circuit 2015. And the 11th Circuit found that we reject the defendant's argument that because the confessional statements may be proof that a RICO enterprise existed, which is a necessary element of the RICO conspiracy charge against both defendants, the statements trigger a confrontation right under Bruton. If the defendants were correct, then any incriminating statement made by one non-testifying co-conspirator would be inadmissible against the other, whether or not the statement facially incriminated the other co-defendant. Bruton's narrow exception to the general rule of admissibility does not extend this far. That's what I found.
All right.
So it's only triggers what we were saying earlier, Mr. Stillwell, Mr. Williams, but I was saying YSL or the
Right.
crew, and I cannot find a case that supports that.
All right. I appreciate you bringing that to the court's attention.
Put a 1 in the chat if the state would never do that.
Every attorney has a duty to be candid with the court, even if the case law does not favor the argument they wish to make. And so I appreciate that, because I have to say, unfortunately,
Hint,
everybody
hint.
doesn't do that. So thank you for doing that. Okay. Do we have this ready to play?
So basically, you know, the case law doesn't support Bruton for general broad statements of YSL, only if someone's named or being referred to directly. And yeah, the state doesn't understand candid.
Oh, yeah. Yeah. Man, what mud? You was every day you trip. I thought you were gonna put on Yeah.
Yeah, that's actually the one I was thinking about. I mean, that child starts doing all that stuff unprompted and then maybe gets encouraged to do a little bit more, but I don't think that that shows the same thing as the other piece of evidence that we were talking about. So thanks, but my ruling stands on that.
Can we have a continuing objection if I need?
You may. All right, I'll see everybody at 9 in the morning.
Judge,
Yes.
one thing we did reserve, if you recall, waiting for the order from Judge Glanville on witness number 26, that's Dennis, particularly number 74. We can deal with that tomorrow easily,
Okay.
though.
Great. Dennis, number 74.
It was different going through this, starting late, skipping the
Mr. Harvey, was that
recesses.
one of the lyrics issues, or was that a different item?
Well, it's lyrics, but it's a video.
Okay,
Thank you.
thank you.
I think they're winding down. So they said 9 a.m. tomorrow, no more half days. And yeah, I mean, pretty interesting day. The judge seems to be fed up with the cumulative stuff. And I'm not surprised. I think everybody except the state is against seeing the same thing over and over and over and over and over. And part of me thinks it's disorganized, but then the other part of me thinks they're doing it to try to bolster. If we bring Dennis back up before and after a shaky witness, we can have Dennis steer the ship back on course if the witness doesn't do what we want them to do. So if we plan in advance to keep bookending all these witnesses with people we know that will speak on our side in our favor, then we can correct course with the evidence, the witnesses that we need, but can't really trust to deliver things the way we need them to deliver them. So I think a lot of it's disorganization, but I think a lot of it's strategic. We need to keep doing this stuff over and over to keep bolstering the thing that we want the jury to take away, and hope everything else that we don't want them to hear gets lost because we're not repeating the things that don't help us. So just crazy. And there we go. Okay, so they didn't come back. That was definitely a big difference watching it. I don't think we finished much later than they recessed. They recessed about 35 minutes ago, according to Joseph Papp. So, and then speaking of Joseph Papp, he did pull this up and said that here are some of the lyrics the state plans to introduce. And I don't know if what's in the screenshot is the exact demonstrative that will come in, but assuming it is, you can see how it goes like line by line, but it's including multiple people here for this one line. So are all four of them supposed to be saying this, or are all four of them on the song and they want to use this one line, but they're just putting all the four faces here? So I just beat a murder rap, paid my lawyer $30 for that. Me and my slime's above the law. Honestly, truth be told, YSL won't fold. Pick up his nose off the balcony. You can read these on the screen. And then this one, I do think there's a small exception here because this seems like general expressions or sayings. But this one here, I shot at his mommy, now he no longer mentioned me. I mean, this is a little bit more specific. So, and I would still say, lay the foundation. What specific incident are you trying to tie this to? But I see why some of these could be really dangerous, but I think there needs to be specificity. You guys may have seen me put in the chat, there's a Joyner Lucas song, and I can never say the last name, so don't make fun of me for not being able to say the last name right. Let's see, we'll go to, nope, not the video. Let's get some lyrics. It's kind of like a ballad, so he goes through this whole story, but he's speaking from a third person. The story is not Joyner Lucas's story, but he goes through this story. This guy gets in like a bad way with people. He's going somewhere. He thinks he's about to fit in with this group, but then they end up trying to like kill this guy. It's apparently somewhat based on a real story, but it's not Joyner Lucas's story. But in a way, you could say, all right, well, if we're going to use lyrics against people, how do we know that they are the subject of their own song? That they're not just telling a third-person story or coming up with something completely fictional. And so this rule of completeness argument is really important. Recused Judge Glanville earlier had given another example. If we look at, let's see. We went over it a bit with the Bohemian Rhapsody. If Love wanted to just introduce Mama just killed a man on text and doesn't put a comma, the jury could interpret that differently than the rest of us are interpreting that. And Love seems to want to introduce a tiny, tiny bit without the actual context that explains, no, they're not saying that Mom did that. It's a confession that I'm the one that did it and I'm telling my mom. And then same thing if we go over, let me get lyrics on the screen here. And it just bothers me because, free speech is a lot of talk of freedom of speech doesn't mean freedom of consequences. But in this instance, we're talking about the state, the government trying to use your speech against you. So they have a high burden. They should have a high burden. We can't just look at anything you've said ever and decide it should come in because you've always meant it literally and as an honest confession of your daily walking behavior. But here with this example, with this LL Cool J song, if, for example, Love just wanted to introduce this, what's highlighted, that's all she said. And on text it read, "I'm gonna knock you out, Mama said." Someone could say that they're explaining something that Mom said. But if they read 2 lines, "I'm gonna knock you out. Mama said knock you out." Now it sounds like I'm going to knock you out because my mom told me I should knock you out. So I'm physically going to be the one doing it. But if we don't introduce this, we might read this sentence differently. And it's just such a, it's messy that they're even okay going down that road. And then you guys saying, look at the first line. Yeah, make up a song, then the state finds a crime to fit it. You've got to examine narrative and context. You can't lift a line from a song and call it evidence. Yep, so that's a good point too. Elliptical, so it's implied but not exactly stated. And that's why when something's heard out of context, or especially if it's written down, if it's transcribed, or say, for example, they ask, did you hear these words be uttered or sung or rapped or whatever? And they read it out loud, and then the person says, yes, those are the words. Well, we're not actually hearing the cadence and the inflection of how they're said when they're being said. You guys got to watch out with everything now, all these different song lyrics. Yeah, using free speech to jail you. And like I said, if we have a situation where if this song was written by someone in the first person who was actually the person speaking with firsthand personal knowledge, the art of this song is the fact that it's so detail specific. So if this was coming from the first person, firsthand knowledge, I would see maybe an exception here where, okay, these lyrics are less a form of artistic expression about something fictional, but actually something based on reality, rather than an artistic expression that's an allegory of reality. But again, this song was written by Joyner Lucas and not Ross. So, yeah, and people, yeah, that's the thing too. People be saying things just to rhyme, and then they'll recycle it. So it's kind of frustrating. I think that they really need to blur that child's face. Even though the jury's not there, they should be blurring it because they're showing it in court. But we've had, I don't know, we've had like phone numbers read out loud that maybe should have been a little bit muted down, knowing that a lot of people are watching. But yeah. And yeah, she's already letting that video in, but they're letting in the second thing with the same child again. And I think that's rough. I think that's a rough one for the defense. It's not a good look to see a child that's picking up on certain behavior. Doesn't mean that the behavior they're picking up on is anything more than, this is, when we're on video and pictures, we do something with our hands. It might not mean anything nefarious, but the jury could look at that and feel like, wow, what are these people doing? The state's saying they have all these guns and do all this bad stuff, and this poor child is already mimicking them. So it is prejudicial, and just because it's prejudicial doesn't mean it can't come in. The judge has decided it's more probative to see people at a young age following in this thing. So, but yeah, a little rough for the child. And you guys were saying that was Mondo's son, YSL Mondo, the one that's not indicted in this, even though he's a co-founder. I'm not like wishing for extra people to be added to this indictment, but I'm just saying that's interesting. The co-founder is not indicted in a RICO that's alleging that YSL is a gang. So, yeah, I think the child could be acting like when you see a kid like start bouncing when they're trying to dance, when they hear a song and see someone else dancing on a TikTok video. Kids imitate, but they don't really have the same intent behind why they're imitating stuff. So who knows? It'll be something that's discussed. The state will try to ask questions that make it seem nefarious. The defense will do something to clean that up, make it seem less nefarious and just what kids do. And it really comes down to what the jury thinks. The child might be old enough now to be a witness, just call them up. Probably close. I think Cash Money Cass said something like the kid's got to be 15 by now. And then, yeah, great point, Lola Dane. So Eminem unalived a lot of people in his music. Obviously, he didn't do those crimes either. It's just cathartic expression. So, right, where's, not saying I wish to accuse someone of something, but that's then the risk. Should we go after everybody who's ever written a song or written a book? It shouldn't just be about music. It shouldn't be just about one genre of music. What about movies? What about, like, I don't know, these stories where you see like BMF and it'll say like loosely based on real events. Well, should we just be mad at the people writing these stories now? Playing the roles? Going back in time because something is now being expressed, and maybe someone did something in the past, but something that could be fictionalized in this production of BMF might not be reality of what actually happened. But what's the difference? What's the difference? I don't know. And it certainly shouldn't be limited to one genre of music. Although I would say the protections might need to be higher because there's a reverse explanation here, right? If the image that sells a certain theme, certain genre, is one way, business sense would tell you to play into that imagery. So a reasonable person, and again, this comes down to the jury and both sides making the arguments rather than admissibility, judge making evidentiary rulings. This would be after the stuff comes in for the jury to weigh on. But a reasonable person could conclude, well, look, they're doing all this because they actually did these things. And maybe another reasonable person could conclude, well, they're doing all these things because they're trying to sell albums. So at a certain point, it's not really the judge's decision to say, this shouldn't come in because there could be an alternate explanation. The judge should allow certain things and let the jury to decide. But the problem is the state keeps trying to be deceptive about what they're trying to let in, introduce it without completeness, not really be clear or direct to identify what they plan to introduce. Because I guarantee you, when we start getting up to these things in the trial in front of the jury, they're going to start to try to introduce these things, and the defense is going to have to go, wait. You said you were going to introduce that with all of these lines. And now what we're looking at here only has 2 of the lines. And we're going to have to go through all of that. We're going to send the jury out, fix this thing that the state's never going to listen on. So it's really frustrating to watch this trial take so long. And the state keeps trying to do the same tactics over and over and over again that keep dragging it out further. But that's another rant. Shout out to Mocha, Miss YSL Rant. I got to pull up her link when I get a second. We'll close out with giving another drop to Mocha because she's doing the YSL rants. So if you need to let off some steam, you guys can hang out with Mocha after this. And then FFS, thanks so much, says, you better unalive me. I'm gonna be another rapper dead for popping off at the mouth with, oh, it's an Eminem lyric. So look at this, perfect in tandem. But popping off with things I shouldn't have said, but when they unalive me, I'm bringing the world with me. Eminem. Look, so that sounds like now are you plotting like a mass event? Like how far did we read into this stuff versus deciding, oh, there's actually weight here, there's merit to this. But we know Eminem sells tons of records with lyrics exactly like this. These are literally his lyrics. So most reasonable people could conclude it's just an expression. So, and yeah, that's exactly why I think this one lyric was dangerous. So, tied to the people that said he shot at Lucci's mama's house. So this one I understand. You might not like hearing me say it, but I see why this one might be probative. Probative enough to just be like, okay, these are just random sayings. What's the probative value of some of this? Some of it's just rhyming. It's not really, and who's actually saying this, right? These 4 people, this is weird. Get some clarity here. But this one could be probative to a specific incident. So I think the defense will have a hard time fighting against this one. And honestly, fair enough. But, and not for nothing, but you let a bunch of lyrics go in. Tons of lyrics, jury's getting bored listening to it. And then you plop this one in the middle of it. That might actually help the defense. Like, all right, we're going to tune out all these other lyrics. And we're not really going to pay attention to this one that might be meaningful because the state doesn't do a good job about putting a focal point on what they want the jury to pay attention to because they just try to flood it all in. So honestly, if I was the defense, maybe let some of these vague things just keep coming in because it'll drown out something like this. So there you go. I think we're all caught up, you guys. We will be, yeah, and who wrote the lyrics is still another question. I mean, they'll ask, like, and do you know who actually wrote that song? But yeah. And yeah, also speaking of those, again, it's a video with no commentary. It's just a straight playthrough of everything from the Supreme Court arguments this morning. If you guys want to check out Brian Steele arguing in State v. Riley, again, he successfully obtained a reversal of the conviction at a lower court, but the state is appealing to reverse that reversal. So, Steele, GA, Supreme Court. Check that out. I think it was about, let me see the timestamp on it. It was 41 minutes, so not that long. Let me see. I'm losing Mocha's channel link. And that's so nice, you guys. She was starting, I think she was at about 16 subscribers. And now she's at 38. So I appreciate you guys so much helping someone get their footing. It's rough to do. Looks like Mocha had a channel a long time ago, but she's using it now to do YSL rants. So if you guys want to support Mocha's first YSL rant, that would be awesome. But other than that, you guys, we are all caught up. See you tomorrow sometime. Any final words? Yeah, that was great watching that from Steele. Is anyone live right now? Kayla's live. But Kayla Bumpus is live currently. And then I think since I was late today, I don't really see anybody else talking about YSL anymore because I'm the late one today. So usually we close up quickly and I have other places to send you. So Kayla's talking about in general what evidence can or can't come in. I think all of the recaps for today are over though for YSL. So I think we're caught up and we're good. We're good. I appreciate you guys. It's been fun to speed this up today and 1 1/4 speed through some of those pauses and buffering. But you guys all have a great one. 6:30. This is kind of when we end normally. Very, very good. Very good. Appreciate you guys so much. You guys have a great one and see you guys.